Okay, we are live on YouTube. Okay.
Okay, thank you, Hearing Examiner Gecko. Good morning, everybody. The time is 9:03 in Santa Fe, New Mexico. My name is Patrick Schaefer. I'm Hearing Examiner for the New Mexico Public Regulation Commission, joined by Hearing Examiner Gecko with the New Mexico Public Regulation Commission. We're here on a hearing in the matter of Southwestern Public Service Utility Company's application for revision of retail rates under Advice Notice 341, specifically an evidentiary hearing on the comprehensive stipulation filed in this docket, that is case number 25-00079-UT. Today, we will be hearing from staff witnesses and having them presented for cross-examination to the other parties. So I think without further ado, we can turn to staff counsel and have their exhibits formally entered into the record for evidence, and then the presentation of their first witness. Are we ready to proceed, Mr. Elliott?
I believe so. Staff calls Mr. Larry Blank.
Thank you, Mr. Elliott. We'll go ahead and just read through staff exhibits and offer them into evidence as we have with all the other parties for formality purposes to make sure that they get into the record without any issue.
Okay. Would you like me to do that?
Yes, if we could just go through all of staff's exhibits once and for all and get them entered.
Okay. Staff has uploaded Exhibit 2. That's the direct testimony of Larry Blank.
And you wish to enter it into the record?
You want me to? I can do it the way we normally do it. Is that how you'd like me to do it?
I think we can just staff offers staff exhibit 1, direct testimony, Derek Zigich corrected into the record, and I'll say any objection, and then we'll just go down the list like we have. Yeah, perfect. Thank you.
Staff exhibit 2, that is the direct testimony of Larry Blank. Staff exhibit 9, that is testimony in opposition to the stipulation. And staff exhibit 9A, which is the SPP oath.
Great. Are there any objections? Okay, they're admitted. Mr. Elliott, maybe I'll just read through all of staff's exhibits like we have with the other parties and get them entered 100% once and for all. So staff exhibit 1, direct testimony, has been stipulated to enter into the record by any of the parties. Is there any objection? It's admitted. Staff exhibit 2 was just admitted. That's the direct testimony of Larry Blank. Staff exhibit 3, direct testimony of Ed Rilkoff. Any objections? It's admitted. Staff exhibit 5, direct testimony of Jonah Malden. Are there any objections? It's admitted. For some reason, staff exhibit 4 was out of order. Staff exhibit 4, Christopher Dunn, corrected, version 1. Any objections? It is admitted. Staff exhibit 5, direct testimony of Jonah Malden. Any objections? It is admitted. Staff exhibit 6, direct testimony of Peter Simbrasi. Any objections? It is admitted. Staff exhibit 7, direct testimony of Edison Jimenez. Any objection? It is admitted. Staff exhibit 8, in testimony in opposition to stipulation of Darren Zigich. Any objection? It is admitted. Staff exhibit 9 and 9A were just admitted. Staff exhibit 10, testimony in opposition to stipulation of Ed Rilkoff. Any objection? It is admitted. Staff exhibit 11, testimony in opposition to stipulation by Jonah Malden. Any objection? It is admitted. And Staff Exhibit 12, testimony in opposition to stipulation of Peterson Brasi. Any objection? It is admitted. Thank you, Mr. Elliott. You may call your
Hearing
first
examiner,
witness. Yes,
hearing examiner
Mr.
Gecko,
Pearson.
or not Gecko, Schaefer. I'm sorry about that. I do have one question about what I believe was Staff Exhibit 9 or 9A, which was the SPP oath. When we
Yes.
saw that in the Dropbox, we assumed that was for purposes of cross-examination. That wasn't a direct pre-filed exhibit. And so I was unclear whether we were going to object when you just made the list or earlier. I have no problem if we want to take judicial admission of or administrative notice of the oath. I mean, it's out there, it's the law. I don't quite understand if we need to admit it as part of someone's direct testimony when it was not submitted as part of their testimony, at least at the pre-filing stage.
Sure. Yes. Well, in that case, Mr. Pearsall, the hearing examiners will take judicial notice of this and enter it into the record.
Okay.
Thank you. Okay. Yes, Mr. Elliott.
Mr. Hearing Examiner, I just wanted to make sure we also have Exhibit 1, Mr. Zigich's corrected testimony.
Yes, I believe I
see version.
referred to that.
Okay.
Maybe let's just check the record to be 100% sure. Yes, at 9:06, staff exhibit. Okay. So this is why the naming conventions become important. Exhibit was misspelled with, yeah, so, okay. Staff Exhibit 4 is, there seems to be, okay, Staff Exhibit 4 is Christopher Dunn corrected version 1. Okay, so that again doesn't follow the precise naming convention for what the hearing examiners required. So this is prepared direct testimony of Christopher Dunn. That is Exhibit 4, and that's corrected version number 1. And Staff Exhibit 1 is direct testimony of Darren Zigich, corrected version 1. So maybe I'm not sure what the difference is between the two.
Excuse me, Mr. Hearing Examiner, they both had corrections.
Okay, so what's the final version, Miss Amer?
The corrected version.
I think they both say corrected.
Oh, are you supposed to say corrected version 4 for Mr. Dunn?
Miss Amer, we want to know what exhibits are the correct and final corrected versions to enter into the record.
Exhibit 4, direct testimony, corrected version number 1.
And that replaces Staff Exhibit 1, direct testimony of Darren Zigich, corrected version number 1. Is that correct?
No, that's Mr. Dunn's testimony is Exhibit 4. Exhibit 1 is Mr. Zigich's direct.
I see. Okay. Excellent.
Both are
Okay.
corrections.
Okay. All right. Excellent. So
separate corrections.
yes.
So yes. Exhibit 1 is Mr. Zigich's corrected version, and Exhibit 4 is Mr. Dunn's corrected version.
Okay, so right, Staff Exhibit 1, I believe we admitted also at 9:06, where I said Staff Exhibit 1 has been stipulated to and entered into the record by the parties. Is there any objection? And at 9:06 and 7 seconds, I said it is admitted. So, Mr. Elliott, it should be admitted into the record.
Okay, thank you. And then just
the
last question I had is, and it relates back to yesterday, Mr. Brasi has a correction to his testimony. It's one number. Normally I would ask, do you have any corrections? And he would identify it. and then we could upload the corrected version?
Yes.
Okay, so
So,
that's my plan for today.
okay, yes, I thought that would have been done yesterday, but I suppose we can get to it as soon as you can get to it, Mr. Elliott.
Okay, all right. Thank you. I appreciate
Okay,
it.
sure.
I'll upload it now.
Thank you, Ms. Amer. Okay, let's proceed with our witnesses and our cross-exam. Go ahead, Mr. Elliott.
Dr. Blank, Mr. Blank, would you just tell us who you work for?
Excuse
Oh,
me.
okay, wait 1 second. Yes, we need to swear the witness in.
Thank you.
Good morning, Dr. Blank. Can you hear me?
Good morning. I can hear you.
Good, thank you. Good morning. As you know, the court reporter will swear you in once he gets situated, and then we can proceed with direct and cross-examination.
Yes, sir.
Dr. Blank, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, nothing but the truth.
Yes, sir.
Thank you. Go ahead, please.
Dr. Blank, just for the record, would you please identify your employer in this proceeding or who you're testifying on behalf of?
Yes, my name is Larry Blank. I am principal consultant of Tahoe Economics, LLC. I'm under contract to provide expert witness testimony on behalf of the PRC staff, Public Utilities Division of the PRC staff.
That being said, Mr. Hearing Examiner, I pass the witness.
Thank you, Mr. Elliott. Now, we have first in our order of cross-examination, 30 minutes reserved by SPS. Is that still correct, SPS?
Hearing Examiner Schaefer, we've decided to pass on cross-examination.
I don't know. I don't know who's speaking.
This is Patrick Pearsall on behalf of SPS.
Thank you, Mr. Pearsall. Okay, I will annotate that, and thank you for letting us know. So no cross-examination, no redirect. I now defer to Hearing Examiner Getko to see if he has any questions for Dr. Blank.
I do. It'll just take me a second to bring up a document or two.
I'm sorry.
Examiner.
I'm sorry. I'm sorry. I'm sorry. Mr. Rushoff,
Yeah,
I know, yes, I know exactly where you're going. Sorry for that. My apologies. We have next in order of cross-examination for Dr. Blank, New Mexico Department of Justice with 10 minutes.
Good morning, Dr. Blank. My name is Larry Marcus. I'm with the New Mexico Department of Justice, and I just have a few questions for you regarding the response to the stipulation. In the staff statement in opposition to the stipulation, the staff notes that one of the reasons for, and I'll just read it off verbatim, I guess, from the class allocation, that the stipulation still places disproportionate increases on residential and smaller customer classes. And that even though the stipulation reduces SPS's overall requested increase, residential and small general service will still receive 17.5% increases, while primary general are only about 10.4%. So as I understand that your position is much of the increase is driven by system costs related to large load customers. So residential ratepayers should not pay a disproportionately high percentage. Now, what percentage, do you know what percentage the stipulation calls for in terms of the system average that's being paid by residential, small business, and residential heating customers?
Yeah, it's for the residential, I believe. I don't have it open, but I believe it's 17%, 17.1%.
And how does that relate to the system average in the stipulation?
It'll help to answer your question if I have it open, so bear with me. So I'm looking at exhibits. I'm sorry. So I'm looking at exhibit A, revenue distribution. To the stipulation. And let me correct my prior response, 17.5% increase for the residential classes, as well as small general service. The overall increase pursuant to the stipulation is 12.55%.
So what percentage would that be of an increase? Yeah, I'm asking you to do math early in the morning. Sorry about that.
I'm
I'm
sorry.
asking you to do math early in the morning. Sorry about that. But
the base rate increase is 12.55% for the New Mexico jurisdiction.
so what percentage of the overall base increase are residential ratepayers and small business ratepayers paying?
I think it might be, I'm not sure if this is it in the table. There's a column that says customer class revenue distribution. It says 139%. I'd have to do the math to confirm that.
Okay.
If it's okay, I'll use the calculator on my phone. If that's,
Okay. All right.
yeah. Yes, that appears to be correct, 139%.
And sorry.
I'm sorry, of the system average, just to be clear.
So your testimony in opposition to the stipulation, I believe there's a table in there, and let me pull that up really quickly. It is, and it was in your original testimony as well. Table 2 from Exhibit LB-2 of your direct testimony, which is on page 10 of your testimony in opposition to the stipulation. There's a rate base increase compared to the stipulation, to the system average for residential service, residential heating service, and small general service. Is that right?
Yes.
And what's the rate base increase for residential service compared to the system average in your in table 2?
My recommendation, which is a combination of all of staff's recommendations, would have a standard residential service at 152% of the system average. The base rate increase is 10.11%.
But comparatively, it's disproportionately a larger increase.
No, it's not. You're comparing apples to oranges. And for those of us who conduct banding exercises in the New Mexico jurisdiction, we recognize that when the overall revenue requirement is lower, That gives us more bandwidth to make movement toward cost of service. And so it is correct that relative to staff's system average increase, the increase to residential is 152% of that. Staff's overall recommended increase is 6.65%. So just to clarify, I'm basically agreeing with you, but you need to understand all the data points to get a full understanding of that comparison.
I understand that the overall is smaller, but the relative increase for residential and especially small business ratepayers, which I believe is 184%, is larger. And so I mean, I'm just focusing on the section of the opposition that says that the stipulation puts disproportional impact on residential ratepayers. This is even more disproportional towards the residential ratepayers in terms of an increase. Yes, it's a smaller overall, but proportionally, it's a greater increase. How do you reconcile that with your with the staff's opposition to the stipulation?
Objection.
Mr. Elliott?
Counsel's testifying.
Yes, I agree. Mr. Marcus, what's your response, first of all?
I did have a question. That was all prefatory. So.
Yes, I would. I agree with counsel for staff. Let's make our questions, and also, Mr. Marcus, you have 2 minutes left.
Okay, so you have actually, if that's okay, I wouldn't mind. I'd like to borrow from time from other witnesses because I don't think we have much for the other.
Sure.
Thank you, Mr. Hearing Examiner. So it's more, isn't it more disproportionate? Isn't your recommendation more disproportionate?
The numbers are what they are. I clearly the relative to staff's overall increase, the increase to the residential classes as well as small general service is higher. And the reason for that is because I have more bandwidth working with a lower revenue requirement. And so I'm able to incorporate greater movement, relatively speaking, toward cost of service. But yes, the numbers are different. So it's not a complete apples to apples comparison.
All right. So let's say you have let's say hypothetically we go with the staff's, we go with the stipulated revenue requirement, but you have the ability to do the banding of that revenue. We go with a 90 million revenue or increase, the revenue deficiency of 90 million, and you have the opportunity to do the banding. What percentage of the system average would you assign to residential service? And that's it.
Yes. You're finished?
Yes.
Yeah. The banding at the stipulation revenue requirements of 90 million increase, I don't have a problem with the banding that is in the stipulation. It's the absolute increase that staff is mostly concerned with, I believe. The reference to the document that was filed by staff, I did not write that. It's not part of my testimony. But if I were to do the banding based on $90 million increase, it would be close to or fairly consistent with what I see in the stipulation.
I have no more questions. Thank you, Dr. Blank.
Thank you.
That's the witness.
Thank you. Mr. Marcus, you just used only 30 seconds of extra time. So just for your situational awareness on how much time you have left.
Thank you, Mr. Hearing Examiner.
Okay, so the next party to have reserved time to cross-examine Dr. Blank is OPL. Well, no, it's not OPL. They didn't reserve any time. Is New Mexico Large Customer Group with 15 minutes. Mr. Rushoff, would you like to cross-examine the witness?
Yes, Mr. Marcus actually covered some of what I was going to, but I just have a few questions. Good morning, Dr. Blank. My name is Austin Rushoff. I don't believe we've met. I represent the New Mexico Large Customer Group in this proceeding.
Good morning.
Like I just said, I have some similar questions that Mr. Marcus just asked. I was curious, have you had a chance to review the rebuttal testimony of Justin Bieber in support of the stipulation that was in MLCG Exhibit 6?
It was rebuttal testimony and not the settlement testimony in support.
Correct. It was rebuttal testimony in support filed on July 10th, so it's fairly fresh.
I do have it. I'm not recalling the extent to which I reviewed it.
Okay. Well, I'd like to point you to that testimony to table JB1, which is on page 9. And hearing examiner Schaefer, I think I would share my screen to share that table if that's acceptable.
Yes, please. Go ahead, Mr. Rushoff.
Objection.
Okay. Mr. Elliott, what's your objection?
I just want to make sure that when we get to this table, I want to ask Dr. Blank if he's seen it before. I just want to make
Okay.
sure he's seen it before.
Sure.
Is that table now showing on the screen?
Yes.
And Dr. Blank, I'll give you a moment to review. This is all information that's sort of in other places in the record that Mr. Bieber pulled together for sort of a side-by-side comparison. So what he shows in sort of columns 2 and 3 are staff's recommendation revenue banding, which you can see the footnote points to your direct testimony. And then in columns 4 and 5 are the stipulation revenue banding. So
I see that.
okay, does this information look accurate to you?
Yes, subject to check. The numbers appear to be consistent with numbers I've seen elsewhere in the proceeding.
Okay, and then so I'll look at just that second column there under staff recommended base revenue increase, and those are the percentage increases you recommended for each rate class under the recommended 6.7% overall increase. Is that correct?
I'm just double checking the first number. They appear to be correct, yes.
Okay. And so in that column, and your recommendation was that the residential class should get a 10.1% overall base increase. Is that right?
Yes.
And then if we look lower to some of the larger customers, for example, the total commercial and industrial overall increase is 5.5%. Is that correct?
Yes.
Okay. So you recognize that at least in your recommendations, the data and record in this case shows that the smaller customer classes should receive larger percentage rate increases than the larger customer classes, correct?
Yes, using the cost of service results as kind of bookends, for guidance. And so, yes.
Okay. So that's based on your review of the cost of service results presented in this case.
Yes.
Okay. And then looking at columns 4 and 5, and I won't review these questions because this is sort of what Mr. Marcus was just getting to, but essentially if you look at the residential service row, the stipulation provides for a smaller increase for the residential class relative to the overall system increase than staff's recommendation. Is that right?
Yes, that's true. And, the reason for that is because we're looking at a higher increase. And so unfortunately, we're not able to make as much movement toward cost of service.
Sure, I understand.
Which is reflected in the 139.5% in this table for the residential service.
Okay. And then, so I'm staying on this NMLCG Exhibit 6, and I just want to scroll to the next page. Where Mr. Bieber, so if you look at this, could you please review this Q&A and this answer right here?
I see it, yes.
Okay, and as you can tell, I've highlighted some text that I want to point you to beginning on line 8 there. The statement is, however, when the different overall revenue requirements are considered, the stipulation actually provides a greater degree of rate moderation for the residential and small general service classes compared to staff's recommendation. Do you agree with that statement?
One moment. Actually, the two are comparable. So I don't agree with the statement. The two are comparable. And the reason I'm saying that, as his statement suggests, taking into account the different overall revenue requirements, if we go back to his table,
Do that.
his table JB1, staff's overall increase is 6.7%, system increase. The stipulation is 12.5. So the difference, if just looking at the residential standard, the difference is about 5 percentage points, right? For under the stipulation. And it's not quite 5 for the staff's difference, but it's within a range. It's close. And
Okay.
so
And
that part of his statement I would disagree with. I think the two are consistent with one another.
right, and we've talked about the difficulty of sort of comparing apples and oranges, given that we're comparing these rate increases at different overall revenue requirements. And to confirm, Dr. Blank, you did not propose a revenue allocation at the stipulation overall revenue increase, correct?
No, I did not.
Okay. And so if we looked only on the screen here at columns 3 and 5, and not on the actual percentage increases, we're just looking at the increases relative to system average, you would agree that the stipulation provides greater rate moderation relative to system average than staff's recommendation?
No, I don't see it that way. Again, as I stated earlier, they are comparable.
Okay. Do you agree that an increase at 152% relative to the system average is greater than an increase of 139.5% relative to the system average?
Well, obviously the number is greater.
Okay.
152, but I don't agree with the statement. Again, I go back to the comparison I just made. We're looking at about 5 percentage point difference from the overall system average under both staff's recommendation as well as the stipulation. From that point of view, the two are comparable to one another, at least for the standard residential service.
Okay, I think I'll leave it at that. Thank you very much for your time.
Yeah, thank you.
Thank you, Mr. Rushoff. You have, for what it's worth, 5 minutes remaining of cross-examination time.
Thank you.
Mr. Hearing
Yes,
Examiner,
Mr. Elliott. Yes,
am I to wait till all of the witnesses go into redirect?
yes.
Okay.
Okay, next for cross-examination is CCAE with 10 minutes reserved for this witness.
Apologies. CCAE does not have any questions at this time.
Thank you, Ms. Lynch. Okay, the next party to have reserved time is FEA LES with 10 minutes for Dr. Blank. Is that correct, Ms. Miller?
Thank you, Mr. Hearing Examiner. I believe my questions have been asked, so I do not have any further questions for this witness.
Excellent. Thank you very much. And finally, for cross-examine of this witness, Walmart has reserved 10 minutes.
Thank you, Your Honor. Our questions have also been answered, so we'll waive our cross.
Thank you. Okay, so all cross-examination has been completed, and now I turn to staff counsel for redirect.
Thank you. Dr. Blank, could you please open, what exhibit is this? This is the testimony in support of the stipulation of Justin Bieber.
Yes, I have it open.
Okay, can you scroll down to page 5? And if I may, I'm just gonna share my screen so that
Yes,
everybody...
absolutely. Just for our working relationship together, I think it's entirely appropriate and helpful when parties share tables or certain parts of testimony on the screen. I think that keeps all of us on the same page and facilitates our examination. So I think the parties should feel free to do that. Obviously, check with the hearing examiners, just to make sure. But I do think it does help our inquiry and the proceedings.
So Dr. Blank, this is a different table, JB1, than the one we were just reviewing, correct?
Which page are you on?
5. And this is Mr. Bieber's testimony, stipulation testimony.
Okay, sorry, I was in the wrong one. Bear
Yeah.
with me. Okay. I need to open that up.
Dr. Blank, are you able to see it on the screen?
It's a little, I'd like to see the original. I'm sorry, hearing examiner.
No worries, no worries.
Yeah, I guess I can see it. I'd like to verify what I'm testifying to, and
Absolutely,
if
absolutely.
you-
Also, Mr. Elliott, maybe you could zoom in a little bit on it too. That might.
Sure.
I'm good now, hearing examiner.
Okay, thank you.
Okay, so Dr. Blank, this is the stipulated class rate increases. This is the total residential. Is this is under the current revenue requirement, correct?
Objection.
Mr.
said that.
Pearsall, Mr. Pearsall, Mr. Lee, Mr. Pearsall. Yes,
These
what's
are
your
leading
objection?
questions. This is the second leading question. On redirect, I don't believe that's permissible.
Mr. Elliott asked, this is the stipulated class rate increase. Wait 1 second, I'm just going through.
Yeah.
Oh, I have to pause this for a second. Okay.
So this is the
So it's-
stipulated increase, correct? And then he said this is,
Right.
before that, this was a different chart than the prior chart, correct? And so that's not how redirect. And I just want to get this out there now so that, if this is going to be a series of questions of leading to a certain point, they should be framed in the proper redirect fashion.
Yes, I appreciate that. Mr. Elliott, what's your response?
Let me try again.
Okay.
Dr. Blank, you were asked about table JB1, correct? From Mr. Bieber's rebuttal testimony.
I believe it was JB2, but yes. In his rebuttal testimony. I thought it was JB2, but yeah.
Objection.
Mr. Pearsall?
He wasn't asked about table JB1. He's misstating the previous testimony.
I believe Mr. Pearsall's wrong.
Okay, Mr.
Your
Pearsall.
witness just said he didn't talk about it.
Okay.
If
Mr.
counsel's going to object to every question I ask here, we're going to be here for a while.
Okay, let's everybody just take a deep breath here for a second. Mr. Dr. Blank, you testified earlier to table JB1 as well. Is that correct? In separate testimony?
Well, I have to go back to that one. I don't know what the number was, but yes, I was answering questions related to a table and Mr. Bieber's rebuttal stipulation testimony.
Okay, so I will sustain the objection, Mr. Elliott, and let's try to ask Dr. Blank questions that were within the scope of the cross-examination and that are in the form of direct examination. Obviously, there is some ability for some contextual orientation, but let's make sure that our direct examine or redirect questions are properly formulated.
Hearing examiner Schaefer.
Yes, hearing examiner Gecko.
Can I interrupt for 1 second? I don't know if it was intentional or not, but emojis during the hearing are not expected to occur other than raising hands. I just wanted
Thank
to
you. I
note
didn't
that.
see that. Thank you for noticing that. This is something that I think is very important that hearing examiner Gecko mentions.
I'm trying to raise my hand. I think I hit the wrong raise hand button, but I'm trying to raise my hand to ask for clarification from the hearing examiners. If Mr. Pearsall is SPS's attorney and he waived cross-examination, is he allowed to object to redirect?
Okay. Ms. Amer,
Ms. Amer was also not the attorney putting on Mr.
I know,
Blank,
right.
so.
But but you weren't.
Ms. Amer, we have to proceed through the hearing examiner. Otherwise, it's going to turn into a shouting mess. Okay.
Exactly. That's why I'm asking for your.
Right. Okay. So raise your hand or say, Mr. Here, Ms. Amer, please let me finish.
One at a time, please.
Exactly. Please let us finish for the sake of the record and for sake of organization. So the witness is being sponsored or the Okay, so Mr. Pearsall is objecting to the form of the question from Mr. Elliott. Is that correct, Mr. Pearsall?
Yes, I was both to the form of the question, and the second objection was to beyond the scope, essentially, of the direct or the cross-examination, which
Okay.
you acknowledged earlier.
Yes, and we'll get to you in 1 second, Mr. Rushoff. Now, Mr. Pearsall, what is your response to the objection raised that is improper for you to object to the form of the question?
While I waived cross, or SPS waived cross, I think that would, in a world where there was all parties waived cross, then we would essentially have nothing to object to, and redirect would be limited. The fact that we waived cross does not mean that we have waived rights to ensure that staff and any other party properly does redirect within the rules and procedures of this tribunal.
Thank you, Mr. Pearsall. Mr. Rushoff?
I was gonna say something similar. I think the right to object to questioning is a right that every intervener has. I would feel the need to object to the questions if I felt so. So I just wanted to respond to Ms. Amer and say ensuring that questioning is done within the rules of evidence is every party's responsibility.
Mr.
Okay,
Hearing Examiner, if I may respond to that.
yes, I just couldn't see your hand, Mr. Elliott, but yes, I was going to turn to you to give a response.
I'll just note that that would be a change in typical commission hearing procedures, where we've only limited for allowing all parties to object during cross-examination. Secondly, and I'm not sure if I responded to Mr. Pearsall's objection to this being outside the scope, I would say that it is clearly not, because Mr. Blank was being asked about calculations and referenced, was asked to do certain math on the fly. So here's the chart where also Mr. Bieber provided, and it's also called JB1. So I just want to make clear here's math. Does this confirm what he was discussing in his direct?
Okay, so with respect to the second issue, Mr. Elliott, I'm going to overrule the objection. I believe it is within the scope, and allow you to proceed on that fashion. I will say, though, that the hearing examiners and as the parties that have been in hearings with this hearing examiner before know that I also raise issues about proper cross-examine form of testimony, even sua sponte, independently. So I'll say, regardless of the objections raised by SPS counsel, that it is important for redirect and direct questioning to have proper form. So I just reiterate that to you, Mr. Elliott, to proceed with proper forms of questioning. So you may proceed with your witness, Mr. Elliott.
I think I've gotten what I needed done. Thank you. No further questions.
Thank you. Thank you. So any recross by the parties that cross-examine this witness? No recross? Okay, I believe all the parties then who have reserved time to cross-examine have done so. Hearing examiner Getco, do you have any questions for Dr. Blank?
I believe I do, and I'm still seeing a shared screen, I think. Thank you. Let me get organized a little bit. I move things around and the screen shared. Uh, Good morning, Dr. Blank.
Good
There you are.
morning, hearing examiner Gecko.
Um, in Alexander G. Trowbridge's rebuttal testimony in support of the comprehensive stipulation, and this is just a known fact that I just have it referenced that way of the stipulation adopts the use of a single peak demand, 1 CP system load factor in the average and excess for coincident peak, the AED 4 CP demand allocation methodology. And I recall that your testimony recommended your direct that be placed, that could go into effect in the next rate case. Is that a proper recollection of your testimony?
Close. Let me clarify. So what the stipulation has inserted is a modification to the 4 CP average and excess demand method that was utilized by SPS. And the change caused by the stipulation is to use 1 CP for the calculation of the load factor weight, but it still retains the 4 CP for the calculation of the excess demands for each of the rate classes. And then my testimony, I did have a reference to the same item, which is the use of 1 CP as the metric for calculating the system load factor. I clearly did not recommend any change to the cost of service study in this case. We'd have to go back to the words of my direct testimony. However, what I'm recalling is it was a suggestion that if you are going to use average and excess in a future rate case, consider utilizing a 1 CP for the calculation of the load factor. So that statement is in my testimony, but I recommended no change to the cost of service in this case.
And so that was discussed yesterday a fair amount, and in respect to disagreements over this, now that you've clarified your recollection of the testimony and without my pulling it up and taking us there, can you speak about your motivation for your testimony, that why you think that is more appropriate as opposed to now, so that I can understand that debate a little bit better?
Yes, let me pull up that section of my direct so I have the words in front of me.
Okay.
So this is found on page 14 of my direct testimonies, starting on line 14, and it continues on, where I recommend, well, first of all, to answer the question stated there, I'm not recommending any change to the cost of service model in this case. For future rate cases, I recommend that the system load factor used to weight average demand in the average and excess demand method be calculated using the single system peak demand. And this is consistent with the way other jurisdictions have done it. There's actually a statement in the 1992 NARUC Electric Cost Allocation Manual emphasizing that you may want to use a different demand measure for calculating the load factor versus the demand measure that you use to calculate the excess demands. but I also go on to emphasize the stipulation agreement in 2585 UT, in which there's plans to convene a working group to study all aspects of cost allocation. And so this is not in any way to deter or to influence those discussions.
Okay. Thank you for that. And because you mentioned it, I had this question myself just driving home yesterday. Because the NARUC manuals were referenced yesterday. 1992 sticks out to me whenever I see NARUC manuals referenced. Are they, as a professor, and how, is there a sense in the regulatory world that those should be updated for the new kinds of generations and system issues that we face, or is it still a hard and fast, like the first place to go to look for guidance? I'm trying to understand the weight of the NARUC manuals these days, given the 34-year-old age of them.
Well, the NARUC manual covers many different methodologies, and there's no prescription provided by the NARUC manual. However, within the construct of those different methods that are covered by the NARUC manual, there is some guidance, suggestive guidance provided by the manual. But again, it's not a hard and fast prescription in the first place. Ultimately, we recognize the commission's, all state commissions' authority to render decisions based on the record of particular cases and the evidence brought in, and to render decisions that are just and reasonable for both the company and for the customers. And so, again, whether it needs to be updated, one area perhaps where there might be some updates. Currently, several states, I don't know if it's the majority, but there are several states now that are taking a close look at extra large load customers who are beginning to appear on the system. And those considerations are going outside of methods that are covered by the manual, taking into consideration the magnitude of some of these loads that are coming onto the system or anticipated to come onto the system, and the rate base increases that those would cause, and whether consideration should be given to alternative methods, both on cost allocation as well as on power procurement. Whether we should be exploring procurement of power through those large customers, or whether the utility company is the best provider of that procurement of power. So there's a number of considerations. And so that's where that manual, I believe, greatly falls short in taking into consideration the extra large load discussions that are ongoing in many state jurisdictions, and I suspect soon in New Mexico as well, probably as part of those anticipated workshop discussions.
Okay, thank you. Turning to my next question, and I only have a few. There it is. So in rebuttal testimony in support of the comprehensive stipulation, Alexander G. Trowbridge again, if you have that, I'm going to page 7. And
yes, I'm there, Your Honor.
And so there's a question and answer there regarding whether your calculation of the revenue deficiency is an apples to apples comparison. And there's a statement that you applied base period, historical, jurisdictional allocators, which assign lower cost to New Mexico, but continue to use the higher future test year present revenues and billing determinants that SPS filed. And he goes on to say the mismatch between the cost side, the base period, and the revenue side, future test year, produces an artificially low deficiency figure in violation of the matching principle. This is, can you address that? And because this has been discussed a fair amount, and can you address that criticism, please?
Yes. And it's a little bit, I mean, his statement does not provide a complete picture as to what the discussion or the difference of opinion is on this. And so let's start with understanding what are we trying to develop, and what in terms of a just and reasonable allocation between Texas and New Mexico. And what we're talking about are allocation factors or allocation ratios and the development of those allocation ratios. As has been heard during this week, there is the 12 CP production allocator, there is the 12 CP transmission allocator, as well as energy at source. And those need to be developed for both the Texas side, the New Mexico side, and then we also have the wholesale, the FERC jurisdiction, which is relatively smaller in this consideration. So what the company has done is they've relied on their forecast for Texas. So they conducted a forecast of load into the future test year for Texas. They also conducted a forecast of future load for the future test year for New Mexico. And also they made some adjustments to anticipated changes in their wholesale transactions. What is very noticeable when you look at those forecasted allocation ratios is the growth that's projected for New Mexico is substantially higher than what they have projected for Texas. So what that does is it causes those allocation ratios to now become much higher on the New Mexico side, which is shifting the total revenue requirements more so over to New Mexico. My recommendation on this, in no way does it change the overall revenue requirement or the system revenue requirement, which includes both Texas and New Mexico. It's one system. It's one system that just happens to cross a state line. The allocation ratios are critically important to be certain that that total revenue requirement is apportioned between the two accurately. What I have suggested is that using current data, and the data that are in the record now are quite stale. I believe those were developed I think over a year ago. What I have suggested is using current data that are adjusted for known and measurable changes in a fashion that's consistent with the Texas jurisdiction. In Texas, they're not allowed to go beyond that. They are allowed to use current data. They're allowed to update the current data. They are allowed to introduce known and measurable changes. But they're not allowed to forecast out as far as New Mexico allows. So now we have a mismatch between the methods used in the two jurisdictions. But again, what I have suggested is not a pure historical allocation ratio. I did use that as part of my testimony because those are the only data I had available from the filing of SPS. But if you look at my testimony more carefully, I encouraged SPS to update those values, to incorporate all the updates that are allowed in Texas, to incorporate known and measurable changes, so that we could get a more current picture as to the status of the 12 CPs and the energy at source in both Texas and New Mexico. We don't have that in the record right now. And when I look at the future test year statute in New Mexico, you may recall there's a reference to the linkage period. There's a linkage period definition that's provided, and I'm looking at it here. It clearly states that the linkage period is the period of time between the end of the base period and the beginning of the future test year period required by this rule to create a verifiable link between future test year period data and base period data. Linkage data does not constitute a test period and is provided for the purpose of validating the information contained in the future test year. And SPS has provided this linkage data. The problem with the linkage data in this record is that was also forecasted. It's not based on actuals, and nor was it updated. Looking forward to the future, I think we could improve that in the commission's rules by requiring updates as the rate case proceeds, so that we get more current data into the record to fulfill that linkage data and to fulfill what seems to be anticipated here for the purpose of validating the information contained in the future test period. But we don't have that. What we have is linkage data, which also was forecasted and not updated as we've progressed through this proceeding. Maybe I should pause there. I may have strayed a little bit from your original question.
Thank you. Yes, you may have, but you did touch about 7/8 of the way through there on the exact question of with respect to the testimony of Mr. Trowbridge regarding base period jurisdictional allocators and future test year revenues, and I understood you touching upon that with respect to how things are updated. And that's where my question was focused. So I feel like you were able to respond in that particular area, and thank you for the additional regarding, the two states and compared to one another. So thank you. I'm going to move on to my next question.
May I respond to one other thing Mr. Trowbridge stated?
Only if it was directly relevant to the question that I asked.
It was within the same page that you referred me to.
Please, but let's not let it go on forever.
Sure. He states that I ignore, I don't have it open right now, but basically that I ignore load growth or I deny load growth. I'm not denying load growth at all. What we're trying to come up with, and what I've tried to recommend, is an approach to arrive at a just and reasonable jurisdictional allocation ratio. That's not a denial that SPS is experiencing growth and will experience growth on its system. So I just wanted to clarify that.
Okay, thank you for that. Okay, let me see what else I have in my document here for just 1 second. Okay. Let me make sure I'm in the right page. This is the second question that I had on my mind that I didn't understand. Still in Mr. Trowbridge's rebuttal testimony on page 14. And there's a question that Mr. Trowbridge answers regarding PRM adjustments. And this was discussed yesterday as well. And it is I want to give it as a little bit of an open question, but let's keep it to this. And can you help me understand this criticism and your response to it?
Yes. So the stipulation, first of all, adopted my recommendation that there should be an adjustment for the Cunningham BESS and any future capacity that's directly assigned to New Mexico, so that New Mexico receives the full credit for that capacity that New Mexico is paying for. In the stipulation, for the first time, they introduced an adjustment to my adjustment. Okay, so they introduced this PRM concept as an adjustment to the Cunningham BESS accredited capacity. And the accredited capacity is already a conservative, it's lower than the nameplate capacity of the battery energy system. So it's already a conservative capacity measure to be used to offset the 12 CP jurisdictional allocation ratios. Now, the PRM adjustment that they made, which you can go to Mr. Hertz's testimony, because he actually sponsors that PRM adjustment in his first I believe it's the first attachment to his testimony in support of the stipulation. He includes PRM adjustments for all 12 months of the year. Now, what we heard from Mr. Gable, he helped to clarify, which I agree with, that the SPS follows the SPP, Southwest Power Pool, resource adequacy requirements for both the winter season and for the summer season. The winter season is December 1 through March 30th, and the summer season is June 1 through September 30th. I'm forgetting whether there's 30 or 31 days in September, but through the end of September. Okay, so what that means is there are 4 months in which that fall outside of the winter season, and the SPP defines summer season. Yet Mr. Hertz's implementation of the stipulation PRM adjustment shows an adjustment for all 12 months. So that's one problem that needs to be rectified. Secondly, which is a more general concern with this adjustment, is that what we're talking about is capacity to meet resource adequacy requirements of the Southwest Power Pool, which includes the PRM. That resource adequacy is met by a large portfolio of capacity sources, some of which fall outside of the rate base, which we are trying to allocate here. That's what the jurisdictional allocation ratios are intended to do, is to allocate the rate base between Texas and New Mexico. But when it comes to resource adequacy, SPS, first of all, they plan resource adequacy for the entire system. We don't pull out one resource like the Cunningham BESS. We don't pull out one of the gas-fired power plants and conduct this analysis. Resource adequacy is done for the entire SPS system and submitted to SPP to comply with those requirements. So the other primary problem I see here is that you're making a PRM adjustment per the stipulation to all months of the year, and you're applying it to a single resource, which is the Cunningham BESS, which is not how resource adequacy is determined for SPS. And we also know that some of the resource adequacy is met by resources such as, I think there's been some testimony on interruptible loads, for example, helping SPS meet their resource adequacy. There are purchase capacity arrangements or contracts that are outside of the rate base that are used for that purpose. And so to apply this PRM adjustment to Cunningham BESS, it requires or resource adequacy taken into consideration generally requires a lot more thought. And cannot be just simply inserted seemingly last minute in this case as part of a stipulation. This requires thoughtful consideration and to make sure that it's done properly so that we are not over adjusting capacity that has been directly assigned to New Mexico, which New Mexico customers will be held 100% responsible for the cost recovery.
One precise follow-up question. Falls outside the rate base. Can you define that in 5 sentences for me, please?
Certainly.
Because I always understand all resources, once they're jurisdictionally allocated to New Mexico, to be contributing to the rate base, to the revenue requirement for New Mexico. Once the commission makes a decision on jurisdictional allocation. And so I'm lost when I hear outside the rate base.
Certainly. There are hard physical capacity investments that have been made by SPS, and those are placed into the rate base. But when it comes to things like interruptible service arrangements with customers that become accredited by the Southwest Power Pool, that's capacity that's not in the rate base. Yet it's capacity that's serving the resource adequacy requirements that SPS must meet. And so you don't have that capacity is not in the rate base. Purchase capacity agreement. So if SPS is purchasing capacity from other providers, or I don't know this to be the case, if they are relying in part on their sister company up in Colorado, Public Service Company of Colorado, if Public Service Company of Colorado has some excess capacity, there could be an arrangement with SPS to count some of that capacity for SPS to meet its resource adequacy requirements with SPP. So those are 2 examples or 3 examples of where there can be capacity you relied upon by SPS that are not part of this rate base, for which we're trying to identify the right allocation ratio for that purpose.
Okay, that's helpful to me. I understand what that reference means now. Thank you, Dr. Blank, and that is the extent of my questions. Thank you.
Thank you, sir.
Thank you, Dr. Blank. So just for everybody's awareness, we're about 1 hour and 15 minutes into the morning session of our 4th day of this hearing. And I'm always very cognizant of our needs to take a break and for Mr. Lee most of all. So I'll just ask Mr. Elliott if he has some specific follow-up for Dr. Blank, just very narrow follow-up, any clarifying questions that relate to hearing examiner Gecko's questions, and if he feels how much time he might need for that.
I have no redirect.
Okay, great. Thank you, Mr. Elliott. So why don't we go ahead then at the essentially 75-minute mark of our opening session and take a 10-minute break and come back on the record here at 10:34 a.m. And we're in recess till then. Thank you, everybody. Mr. Lee,
Yes, Judge.
is my camera working?
It is not, Judge.
Okay, there's some software issue here with Zoom. Wouldn't you know? Yes, Mr. Rushoff.
Thank you. I wanted to offer, I don't want to add to any more conclusion, but when Mr. Elliott was asking questions of Mr. Blank regarding table JB1 in the stipulation testimony of Justin Bieber, I was a little confused about that table, and I reached out to Mr. Bieber and realized that that table was labeled incorrectly. So I wanted to raise that for everyone's information and let folks know that we're planning to make a correction to that table, and submit that into the record. So we will work on a red line and share that with all the parties. And then perhaps we can handle that over the lunch hour.
May I ask what exhibit that was so I'll know when it's
Yes. Yes, and I will, oh shoot. I thought I had the exhibit labeled. One moment. Unless, Rick, do you have that handy? I think it's exhibit 4.
Pulling it up right now.
You're on screen now, Judge.
Yes, I had to unplug and plug it back in.
It's NMLCG Exhibit 4 in table JB1 within that exhibit.
Thank you.
Thank you,
And-
Mr. Rushoff. Anything else on that
I
point?
may, I don't know if Mr. Elliott was going to ask what the actual correction is, but I could bring that up and show you quickly and then file one later.
Okay, well, let's before we go too far, Mr. Rushoff, let's just go back on the record.
Oh, sure.
And get all this. Sometimes coffee and motivation can get us a bit over our skis, myself included. So thank you for all this, though. But so we're back on the record, 1034, and Mr. Rushoff is just offering a clarification on a New Mexico large customer group exhibit that arose due to a confusion earlier. So please proceed, Mr. Rushoff.
Thank you. I'm going to share my screen here. And this is the table in NMLCG Exhibit 4 that Mr. Elliott was asking Dr. Blank about. This label right here, increase relative to system average, is incorrect. That should actually show the overall rate increase. So the purpose of this column, of this table, was to show in the second column the base rate increase, and then the third column the overall rate increase, which includes all the riders and other items. I don't know why, but we perhaps didn't catch that before we filed it. So I was planning to submit a corrected version once we can prepare that over the next hour or so. And I'll raise my hand later, I guess, to seek to admit the corrected version.
Thank you, Mr. Rushoff. Thank you mostly for the thoroughness and for the candor. And I think that really helps our procedure and our parties. Mr. Elliott, do you have any thoughts or follow-up based on what Mr. Rushoff is discussing?
No, I think that's a good correction.
Thank you. Thank you, Mr. Elliott. Thank you, Mr. Rushoff. Okay, so I believe Mr. Blank has concluded his testimony and been excused. Dr. Blank, are you there? Okay, Dr. Blank has been excused. And we will proceed to call staff's next witness. Please proceed, Mr. Elliott. Oh, Miss Amer. Okay. Nice to see you.
Yes, introduce Mr. Darren Zigich.
Thank you, Miss Amer.
All right, Mr. Zigich, would you please raise your right hand? You're on mute, sir. You solemnly swear the testimony you're about to give the matter not pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead,
Uh,
please.
Good morning, Mr. Zigich. Could you please state your name
Yes, Darren Zigich.
and what is your position with the New Mexico Public Regulation Commission?
I'm an engineer in the New Mexico Public Regulation Utility Division staff member.
And you probably heard that your direct testimony, corrected version, and your testimony in opposition were admitted into evidence. So I pass the witness for questions.
Thank you, Ms. Amer. So for cross-examination proceeding in order of appearance, SPS had asked for 15 minutes for cross-examination of Mr. Zigich. SPS, would you like to cross-examine this witness?
Mr. Examiner, SPS waives its right to cross-examine Mr. Zigich subject to the ability to ask follow-up questions if necessary.
Thank you, Ms. Hardy. Okay, yes, you may ask. Go ahead, Ms. Amer.
Yeah, I have just a point of clarification. At what point in time would SPS be allowed to ask follow-up questions?
Ms. Hardy, what intention do you have for asking follow-up questions?
Typically, it would be based on follow-up to hearing examiner questions, if there are any, and if we have follow-up questions.
Ms. Amer?
It's up to the hearing examiners. I just wanted to be clear as to it's limited to one series of follow-up questions after the hearing examiner.
Okay. Thank you. Thank you, Ms. Amer. Okay, so SPS has waived cross-examination subject to that condition. The next party in order of intervention that asked for time was New Mexico Department of Justice. Mr. Marcus, Mr. Hayden, would you care to cross-examine this witness? You have reserved 10 minutes.
Thank you, hearing examiner. We would waive our cross-examination for this witness.
Thank you, Mr. Hayden. The next party in order of intervention to request time was New Mexico Large Customer Group with 30 minutes. Mr. Rushoff, do you still intend to cross-examine this witness?
Yes, my colleague, Mr. Arnett, is going to cross-examine Mr. Zigich.
Excellent. Mr. Arnett, just give me 1 second to set the timer here at 30 minutes. And you may proceed when ready, Mr. Arnett.
Thank you. Good morning, Mr. Zigich. I don't think we've met yet. My name is Rick Arnett, and I'm representing the New Mexico Large Customer Group in this proceeding. How are you doing this morning?
Just fine, Mr. Arnett. Nice to meet you.
You filed testimony in opposition to the stipulation, correct?
Yes, I did.
In your testimony, you took issue with stipulation condition 111, correct?
In part, yes.
And specifically, you disagreed with the term directing SPS to use a system single peak demand, or 1CP, system load factor in its revenue allocation methodology, correct?
Correct.
And you took issue with this provision because you believe it conflicts with the stipulation reached in case number 25-00085, correct?
Yes.
And specifically, in your opinion, the stipulation in this proceeding, condition 111, conflicts with section 113, condition C of the case number 25-00085 stipulation, correct?
Objection. The witness should be allowed to actually look at his testimony and not have it paraphrased by counsel for New Mexico Large Customer Group.
That's fine. I think also, Ms. Amer, Mr. Arnett, what's your response to the objection?
I'm happy to share my screen. I have his testimony in front of me. So whatever you direct, hearing examiner.
Sure. I'll just say also, Ms. Amer, if a witness is capable of, I believe, stating or responding to whether or not the cross-examining counsel has correctly or incorrectly paraphrased or characterized pre-filed testimony. That being said, I think that your point is well taken, that there's also nothing wrong with demonstrating on screen, as Mr. Arnett has signaled his willingness to do, of that witness's testimony for purposes of cross-examination. So, Mr. Arnett, if you're not opposed, please, direct the witness to his testimony that you're referring to.
Gladly. I'm going to share my screen now. Do y'all see Mr. Zigich's testimony?
Yes.
Okay, so I was referring specifically to, let me get to it. Right here. So lines 1 through 4. And I can restate my question if you would like.
Sure, go ahead and restate it, I guess. Thank you.
Okay. So in your opinion, stipulation condition 111 conflicts with section 113 condition C of the case number 2500085 stipulation, correct?
Correct.
Are you familiar with the section 113 of the case number 2500085 stipulation?
Yes, I am.
Okay, and we provided this language in exhibit number 6 of Justin Bieber's testimony. It's language from the section 113, case number 2500085 stipulation, and I can share my screen with that, or I can restate that here. Any no objections, though, I'll just go ahead and restate that language. So that provision required SPS to convene a working group with stakeholders and staff to evaluate and analyze alternatives to SPS's current retail customer class cost allocation for both capacity and energy costs, correct?
Correct.
Otherwise, the provision requires SPS to present the results of this analysis in its next rate case, correct?
Correct.
Mr. Arnett, let me just pause 1 second here, just for housekeeping purposes. Often when testimony is read, the reader proceeds sometimes very quickly, and that could be a challenge for the court reporter. So as we're just reading back testimony, maybe we should just do it a little more slowly so that Mr. Lee has time to adequately capture the record. Thank you, Mr. Arnett.
Understood. I apologize. I'll continue with my questioning. So the case number 2500085 stipulation does not prevent the company from using a particular load factor, correct?
No. It's more the context of when you're going into that discussion. And that's you don't start a working group from a variable stance. You would go in with stay put and then address changes from that stay put position. And what we're doing here is not providing that stay put or steady point of reference to adjust going forward into those working groups. It essentially unravels or changes the starting point that those discussions for 2585 will start at. And that's my concern, is you're fundamentally shifting the starting point as from where we agreed to in 2585. And as the lone oral testimony in that case for staff, I do not find that as an appropriate change to undertake at this point before the working groups even start.
But the case number 25-00085 stipulation did not require a starting point necessarily, and didn't require the use of a particular load factor, correct?
No, but it certainly was not, the testimony of both me and Mr. Trowbridge envisioned many more hours, not just a single point in time, not a 1 CP, but more of a 40, 50, 60 CP stance moving forward. So it fundamentally reverses the course that we had envisioned moving into that.
Thank you, Mr. Zigich. I would now like to ask you about staff witness Dr. Blank's direct testimony submitted in this proceeding. Are you familiar with that testimony?
To some extent, yes.
I would like to point you to page 14, lines 12 through 19 of Dr. Blank's testimony. I'm also happy to pull this up on my shared screen if that would be helpful.
Please do, yeah. That'd be great.
Okay. Here's page 14, lines 12 through 19. Dr. Blank recommended that in the future, SPS should use the 1 CP for the system load factor in its revenue allocation methodology, correct?
Yes, but he's also just testified that he is open to these working groups evaluating the whole system cost allocation methodology moving forward, and acknowledges that the old NARUC manuals are potentially out of date and need to accommodate variable energy resources as has been done. And Mr. Trowbridge acknowledges that that is being done at other utilities. So I don't think this is a final recommendation. This is a suggestion moving forward, but it is nowhere, it is open to interpretation after these working groups really look into all of the aspects of cost allocation.
Thank you. And you agree that condition 111 of the stipulation requires that the average and excess demand allocation method use the 1 CP load factor, correct?
The way it's written now in the stipulation, yes.
And so Dr. Blank recommends the 1 CP, and the stipulation recommends or requires that the revenue allocation method uses the 1 CP load factor, correct?
Correct.
So condition one, excuse me.
Objection. Council is stating a conclusion that that Mr. Zigich did not make. So
Mr. Arnett? Okay, go ahead, Ms. Amer, finish, please.
Either withdraw the question or restate it. Witness did not say that Dr. Blank recommended a 1 CP.
Okay, Mr. Arnett, your response?
He did state that he recommended the 1 CP subject to several other thoughts, but I'm happy to restate the question and move on.
Okay. Go ahead, Mr. Arnett.
So in your opinion, is condition 111 consistent with staff witness Dr. Blank's recommendation? Correct. Would you agree that it is?
No, it isn't, because his recommendation did not apply to this rate case.
But it didn't preclude any sort of revenue allocation in this rate case, and it suggested that in future rate cases, we do adopt the 1 CP load factor, correct?
He's making a suggestion, but not, he's also open to these other meetings, these other workshops, looking at all of the allocation factor. This, I'm not going to argue as to what Dr. Blank suggested, but it's, he states what he states in his testimony. I'm not going to say or try to interpret what he's actually advocating for. I'm just saying that moving from a 4 CP to a 1 CP is contrary to what the discussion was in the 2585 stipulation that staff signed on to. And that if we would have known that you're going to truncate that discussion or change the base that we were starting from, we may have had other views on that stipulation. Therefore, this is contrary to that stipulation.
Thank you, Mr. Zigich. I have no more questions.
Thank you, Mr. Arnett. I'll just note for the record that large customer group has 16 minutes remaining from the time that was allotted to Mr. Zigich. Okay, next party that reserved time to cross-examine Mr. Zigich is CCAE. Ms. Lynch, would you like to proceed with cross-examination of Mr. Zigich?
Hearing examiner, we do not have any questions.
Thank you, Ms. Lynch. Okay, the cross-examination having been completed, I ask staff counsel if they have any redirect for Mr. Zigich.
Thank you. I do. You were asked by counsel for New Mexico Large Customer Group about the starting point for the stipulation in the 2585 case. When the agreement was made in that case, when staff agreed to the stipulation, what was the starting point?
The current application, this application was in-house when the 2585 case was heard and that stipulation was signed. So we thought we were starting from the current application and how it was presented.
And could you state what that is?
That was the 4CP, the AAD 4CP method without the adjuster to the 1 CP.
Right. It was not, was it the 1 CP?
No, that was not in the original application.
And what was staff's understanding when it agreed to the stipulation in 2585 of the starting point for the working group?
That we would, start with their current cost allocation methodology and then see if that was still relevant in an era of variable energy resources and short duration storage resources, because they are fundamentally different. And we basically envision what Public Service Company of New Mexico is going through right now.
Was it staff's understanding at the time that it agreed to the stipulation in 2585 that the starting point would be the 4 CP?
Yes.
Did Dr. Blank recommend the 1CP in this current rate case?
No.
I have no further questions.
Thank you, Ms. Amer, for that redirect. I will ask Mr. Arnett, do you have any recross within the scope of Ms. Amer's questions?
I do not. Thank you.
Thank you, Mr. Arnett. Okay, hearing examiner Gecko and I had just one or two questions for Mr. Zigich. The first question, by the way, good morning, Mr. Zigich. Thank you for being here with us. What is your view of the SPS demand forecast in this case?
The demand forecast?
Yes.
Well, I didn't dig into that all that much. I mean, but I believe it's fairly similar to what we saw in the 2566 resource case and in the 2585 case, which made the case there that they certainly had significant load growth, especially on the New Mexico side, from the Permian Basin. And that was the justification for those new resources. But other than that, yeah, in this case, I think they just essentially moved that forward into this case. All of these cases basically were filed almost contemporaneously. So it's very similar as far as that goes, as far as the load forecasting.
Thank you. Now, Mr. Zigich, I'm going to read to you a brief section from Mr. Trowbridge's rebuttal testimony. This is from pages 11 to 12. That is page 11, line 18 to page 12, line 5. And it's just two sentences. If you want to bring it up, or two or three sentences, if you want to bring it up, that's fine. I can wait for you.
I have it.
Okay, excellent. So, and just for the record and the parties, I'll read it out loud. Because the PRM portion represents a reliability buffer above peak load, not load serving capacity, it is appropriately reflected in the valuation methodology by dividing the seasonal ACAP by 1 plus the applicable seasonable PRM, as set forth in the stipulation section 1.3A and B. Including the full ACAP without this adjustment would double count the benefit and overstate the extent to which New Mexico's load relies on shared system capacity resources. And the question is, does this satisfy your concerns?
It doesn't, partially because above that, on line 13 and 14, he makes this statement of, however, not all of this capacity, he's speaking of the Cunningham BESS, serves contemporaneous load in the same manner as other rate-based resources. And I frankly do not understand what he means by that. That the BESS doesn't serve load the same way any other resource does. We function, functionality. I don't understand that concept. And then the troubling thing was he mentioned the nameplate PRM of 16 and 36%, right below that on line 16. And that troubled us more than anything because that's not fair to use an accredited capacity for the battery and then use a nameplate PRM. It appears through closer inspection that they are not using that they are using the accredited PRM. But still, I think we're not clear as to why that is even in there. And frankly, it's not so much of a big cost issue in this for this smallish battery. But if we're going to start, if Texas is going to start cherry picking these resources, and we're going to start paying for all of the new cars on a lot full of used vehicles, and we pay for the one new car, that is not an even trade. If I'm getting all 4 seats of the new car and they're giving me a 2-seat credit for all the used cars, that's not the same value. And you can't let one state cherry pick what they want to pay for and have us pay for the rest of it. And they certainly allocate these things at the capital expense level. There's other resources that are very close in cost and value as the Cunningham BESS, and they could certainly trade off one for one on other resources. But so I'm not sure we're getting the full value. And then the other concern with the full value of the BESS was there's nowhere in the stipulation that says we get energy credit. Mr. Trowbridge was the first one to state that in his rebuttal testimony, but I don't see that in the stipulation, that we get these ancillary service credits, the energy, the market credit. Maybe it goes without saying, but right now it's just a demand allocation to New Mexico. There's nowhere in there that it states that we get all these other benefits, including market savings in that sense, and ancillary benefits. So that was the thing that we also flagged, was it didn't seem like we were getting the full package of benefits.
Thank you, Mr. Zigich. Those are all my questions. Ms. Amer, do you have any limited follow-up to those questions?
Yes, Your Honor. Can you explain how what Texas is doing regarding BESS in general affects this case?
Objection.
Ms. Hardy?
I think that's outside the scope of the hearing examiner's questions.
I would agree with that, Ms. Amer. That's sustained.
How does the stipulation devalue the benefit of the Cunningham BESS?
Well, like I said, I mean, if there's no energy benefit, Mr. Gable and Mr. Trowbridge both testify that there is real value there, market value, in the arbitrage of ability of the BESS. And if that isn't all being allocated to New Mexico, then that's a drawback. We don't want to pay for all of the capacity and not get all of the benefits. So that was just something we noticed in the stipulation. It only talked about capacity benefit. It did not talk about these other, which has some value to it. And some significant value in some cases. So
how would you have written the stipulations calculation where they talk about the dividing by 1 plus the PRM?
Well, for the capacity, I think both myself and Dr. Blank question why the PRM is in there. I mean, divide it by 1 and be done with it, or just give us the accredited capacity. But then there's also that whole issue of the energy value too, that we would like to see included in the stipulation, or made clear, because Mr. Trowbridge seems to be saying something that isn't specifically stated in the stipulation. he says we will get the energy benefits, but I don't see that in the stipulation.
Would you like that specified in the stipulation?
That'd be helpful, yes.
And would you like the calculation to read just divided by 1?
Okay, I think we're getting pretty far from hearing examiner's questions, Ms. Amer. So unless there's something more specific to the forecast model or the question about Trowbridge's PRM, I think, do you have anything more on point to those two areas?
No further questions. Thank you.
Thank you. Ms. Hardy, did you have any limited follow-up to Ms. Amer's questions?
I do not. Thank you.
Thank you, Ms. Hardy. Okay, Mr. Zigich, on behalf of the commission, we express our gratitude and appreciation for your professionalism and participation in the proceeding. I believe you may be excused.
Thank you.
Thank you, Mr. Zigich. Okay, thank you, everybody. Now, I believe we're ready for staff's next witness.
Yes, we would like to call Mr. Jonah Malden. And I'm not sure if he is on the Zoom. I will notify him.
Yes, Ms. Amer, I'm just admitting him now. He just, the notification came across my screen as you were speaking.
Thank you. Good morning, Mr. Malden.
Just a moment. Mr. Malden, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter not pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead, please.
Could you please state your name
Yes, Jonah Malden.
and what is your position at the New Mexico Public Regulation Commission?
I'm the accounting bureau chief in the utilities division.
And you're aware that your staff exhibit 5 direct testimony and exhibit 11 testimony in opposition to the stipulation have already been admitted into evidence.
I am, yes.
I pass the witness for questions.
Thank you, Ms. Amer. And the hearing examiner notes that SPS had reserved 15 minutes of time for cross-examination of Mr. Malden. Would you like to proceed, SPS?
Hearing examiner Schaefer, SPS has determined that it can waive cross-examination on Mr. Malden, subject to the same opportunity for any potential follow-up questions as Ms. Hardy asked for earlier.
Thank you, Mr. Pearsall. The next party to reserve time is New Mexico Department of Justice with 10 minutes. Mr. Hayden, Mr. Marcus, is Department of Justice still planning to use this time to cross-examine Mr. Malden?
Thank you, Mr. Hearing Examiner. The New Mexico Department of Justice waives its right to cross at this time.
Thank you, Mr. Hayden. The next party in our order of appearance and intervention is New Mexico Large Customer Group with 15 minutes for cross-examination of Mr. Malden. Mr. Arnett, Mr. Rushoff, are you prepared to cross-examine this witness?
We are likewise going to waive our cross of Mr. Malden. For everyone's information, we are also going to waive our cross of Mr. Brossi when that time comes. But I would like to request to transfer just 5 or 10 minutes of that time to Mr. Dunn.
Yes, you said 5 or 10?
Yes, we'll call it 10,
Okay.
but I probably won't do that.
Sure, I'll put 10 there, and I think Large Customer Group has sufficient remaining cross-exam time, and that is taken note of.
Thank you.
The next party is CCAE. Ms. Lynch, are you still planning to cross-examine this witness?
We are also going to waive cross, and CCAE has no cross of any further staff witness.
Thank you, Ms. Lynch. Okay, Mr. Malden, I have no questions for you. And I just reiterate the same expression of gratitude and thanks for your participation and professionalism in this proceeding, and I believe you may be excused.
Thank you.
Thank you, Mr. Malden. Hearing Examiner Gecko is back with us.
Hello.
Okay, now I believe we are ready to proceed with staff's next witness.
Yes, and Mr. Elliott will be introducing Mr. Brossi.
Thank you, Ms. Amer.
Mr. Brossi, would you please raise your right hand?
I just admitted him, Mr. Lee. It might take a moment for him to come online. Mr. Brossi, can you hear us? There you are.
Yes, I can hear you now.
Okay, good morning. Good to see you. Mr. Lee?
Mr. Brossi, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter up heading should be the truth, the whole truth, nothing but the truth.
I do.
Thank you. Please go ahead.
Whenever you're ready, Mr. Elliott.
Thank you. Mr. Brossi, before we start, you mentioned you have some corrections to your testimony.
I have one small correction to my direct on
Would you
page
please
24.
identify that?
Yep. On page 24 of my direct testimony on line 12, I would like to correct the companies and like that to be corrected to staff's weighted cost of debt as opposed to the company's weighted cost of debt.
And
that is my one correction.
Thank you. And Mr. Hearing Examiner, we attempted to upload this, but Dropbox wasn't allowing us to.
Okay, I will recirculate the link that I created yesterday. It should not have had any time limitations on it. So I'll go ahead and make sure that whatever we send to you or whatever we send to you facilitates the uploading of this corrected testimony. Do any of the parties object to the admission of this corrected testimony? Okay, we will admit that subject to the upload and the correction. Thank you, Mr. Elliott.
Pass the witness.
Thank you. The first party that had reserved time for Mr. Brossi is SPS with 15 minutes.
Mr. Examiner, we waive cross-examination of Mr. Brossi subject to the ability to ask follow-up questions.
Yes, thank you, Ms. Hardy. The only remaining party to have reserved time for Mr. Brossi is the New Mexico Department of Justice with 10 minutes.
Thank you, Hearing Examiner. The Department of Justice waives its right to cross-examination.
Thank you, Mr. Hayden. No recross or no cross, so no redirect. I defer to Hearing Examiner Getko for any questions that he may have for this witness.
Thank you, Hearing Examiner Schaefer. I have one or two questions. for Mr. Brossi. Good morning, Mr. Brossi.
Good morning, hearing examiner.
So, and I'm sorry, I'm catching up still a little bit, so I don't have your testimony up yet. I can bring it up. But what I'm referring to are adjustments to the revenue requirement. You testified as to staff's recommendations for adjustments to the requested revenue requirement in the application, correct?
That's correct.
And so one of the major adjustments that was put forth by Dr. Blank with respect to jurisdictional allocation. Correct?
Correct.
What I wasn't clear on was the order of operations and whether that order of operations matters. And here's what I mean. For the dollar values that you testified to for adjustments to the revenue requirement in other categories, not Dr. Blank's category regarding jurisdictional allocation, are those calculations done off of the requested revenue requirement from SPS, or are the other categories dollar amounts calculated off of a lowered amount of just what would be allocated to New Mexico if Dr. Blank's recommendation were accepted?
I believe you're asking about the order of those of our adjustments as we made them into the cost of service model. Is that correct?
Yes, and I'll give it just an example. Like, okay, so revenue requirement in the application, rough number, I remember 177 million is a revenue deficiency. And then I recall Dr. Blank's recommendation being, well, there should be approximately somewhere between 40 and 50 million dollars less than that allocated to New Mexico. So let's just say right now 40. So that would put us at $137 million. Now, the other categories, a $10 million reduction for whatever. I should bring up the testimony in a minute if this doesn't accomplish what we want. The $10 million in my hypothetical, is it $10 million calculated off of the 177 million, or $10 million taken off of 137? I'm trying to get where the starting point was for the additional recommended reductions to the revenue deficiency.
I believe that Dr. Blank's adjustment was one of the final adjustments that we entered into our cost of service adjustments when we were adjusting the model. And so there are about, I believe, let's see, the 56 million is what Dr. Blank's adjustments amounted to, and return on equity amounted to a 20 million adjustment, capital structure a 4 million adjustment, and the rest were accounting adjustments specifically for a sum total of 127 million of staff reduction adjustments.
Okay, so the $20 million on the ROE adjustment,
yes,
that would be done by taking staff's recommended ROE and applying it to a certain balance. Was that applied to 177 million, what the applicant, well, that's incorrect, to the to the capital cost for resources that were submitted by the applicant, or a smaller number? Like, when you said that Dr. Blank's adjustment was one of the last ones to come in, I feel like my question was answered, because it says to me that the other reductions were done based off of the application without taking into consideration first a reduction from Dr. Blank's number. Is that a fair description of the process? That
I would say so, yes, that it is, as yeah, one of the final steps. It does matter the order that things come in, that the adjustments come in, and that was one of the last ones that we did. Yes.
Okay, so then just as a small follow-up to that, with no judgment in my speaking of this question, if Dr. Blank's recommendation were adopted, for proper calculations, would there need to be a recalculation of the other adjustments? Because you would have a different pie for New Mexico that you would be considering. I see the system pie to start out with. A certain percentage goes to New Mexico, and adjustments are made to that. Now, if we make that portion of the pie smaller when we do the jurisdictional split, would it, in your expert opinion, require you to recalculate the other numbers that you have provided in your testimony with respect to reductions to the revenue requirement deficiency?
It is my understanding of the model that we would not have to do that. That while yes, the order does change things, and the number would be different depending on its order. I think that materially it would not make a material difference in the overall number, but that's subject to check.
Okay. Thank you. And thank you for that. And then I recalled, and correct me if I'm wrong, did you testify as to amortization periods and I don't remember the exact item, I'm sorry. I could find it, but I'd need a little more time and because I can ask my question generally of when a stipulation, for example, chooses a 2-year amortization, and I'm not talking about rate case expenses in this case. And did you testify as to, due to affordability concerns, extending that to 3 or 4 in particular cases, or a particular case? Was that in your testimony?
Yes, Mr. Hearing Examiner, that is for a few of the regulatory asset and deferred costs that the company is wishing to recover, including legacy amortization, community solar, and rate case expense, correct? We were making recommendations on a longer amortization period. Specifically, I can recall the rate case expense and legacy meters.
Okay.
Amortization periods for affordability purposes, yes, and the possibility that if the period is too short and the base rate, the next rate case comes before or after that period, then there is a possibility of over recovery by the company.
So here's so I've traditionally seen, discussions about amortization periods as in the context of affordability of having a longer amortization period lowers the immediate impact to rates because you stretch out the amortization over a larger number of years. And there's arguments against that for different reasons. But on the affordability issue and gradualism and avoiding rate shock, that argument's often given. When I was looking at this, I thought to myself, another rate case gets filed soon. If we extend amortization, if the commission made that decision, and something goes to 4 years instead of 2, and another rate case is filed, and within 3 years, we have another set of rates with new rate increases. If amortization hasn't been completed of an item from the initial rate case, then I still have a portion of that. And when I finish the next rate case, I've got another rate impact on top of it. And I thought, to me, it creates a question of, I either get a rate impact now and I get it out of the way in 2 years, for example, if it's a 2-year amortization. And if it's a 4-year and I have new rates that pancake on top of that at year 3, I get a hitch up at year 3 because it's on top of what I've had for the first 2 years. Do you have any thoughts on that? And in the context of affordability, and what it does is it's my framework of we're in an era where load is ramping and there's a possibility of high frequency of rate cases. Does that change that traditional argument about gradualism being helped by having a longer amortization period? There's my question.
Yes, that's an important point here in Examiner Gecko. The period when the next rate case will be filed and that interim between when those base rates from this case are in effect to that next to when the next ones are, that is the consideration here. But staff can't really see the future, and there have been times in the past, both here and in other jurisdictions and in general across the country, where the amortization period has been stipulated to be shorter when in fact it becomes longer. And we were mainly concerned about that outcome as one of the things we consider when recommending these longer periods. But yes, if it is a shorter period, then likely the company will want to recover those costs and include some portion of them again.
Okay, thank you for that. It helps my understanding of the analysis. That's the extent of my questions. The other ones have already been covered. Thank you for taking my questions, Mr. Brossi.
Thank you, Mr. Gecko.
Thank you, Hearing Examiner Gecko, and thank you, Mr. Brossi. I'll just ask first Mr. Elliott if he has any follow-up based on Hearing Examiner Gecko's questions.
No, Mr. Hearing Examiner.
Thank you, Mr. Elliott. Okay, I don't believe there's any other questions for Mr. Brossi. In that case, I express to you also our appreciation and gratitude for your professionalism and contribution to this case, Mr. Brossi. You may be excused.
Thank you, sir.
Thank you. Mr. Elliott, it looks like Mr. Dunn is next, as he just came on to be admitted. Is that correct?
Yes, and Mr. Hearing Examiner, I'll introduce Mr. Dunn.
Excellent. Thank you, Ms. Amer.
Mr. Dunn, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter up pending should be the truth, the whole truth, nothing but the truth?
Yes, I do.
Thank you. Please go ahead.
Yes, could you please state your name?
Absolutely. My name is Christopher Elliott Dunn.
And what is your position with the New Mexico Public Regulation Commission?
I'm an economist with the NMPRC Utility Division staff.
And you are probably aware that your direct testimony, Staff Exhibit 4 corrected version, was admitted into evidence. And so I pass the witness for further questions.
Thank you so much, Ms. Amer. And SPS, if I'm not mistaken, did not reserve time to cross-examine this witness. Is that correct? Ms.
That's
Hardy,
correct.
Mr. Pearsall? Thank
That's
you.
correct.
Thank you. The next party in order of appearance and intervention to have reserved time is New Mexico Department of Justice. Mr. Hayden, Mr. Marcus, do you have any questions for this witness?
Thank you, Your Honor. The Department of Justice doesn't have any questions for this witness.
Thank you, Mr. Hayden. Mr. Rushoff, Mr. Arnett, I believe you asked for 10 minutes for Mr. Dunn. Is that correct?
Yes, please.
Go ahead, Mr. Rushoff.
Good morning, Mr. Dunn. I don't believe we met. My name is Austin Rushoff. I represent the New Mexico Large Customer Group in this proceeding. It's nice to meet you.
Good morning, Mr. Rushoff. Nice to meet you as well.
I have just a few questions for you, and I would like to point to Staff Exhibit 4, which is your testimony, direct testimony in this case, and specifically page 56, where you offer conclusions and recommendations.
Yes, sir.
And I will share that page. Is that visible to everyone?
Yes.
Thank you. And as a preliminary question, Mr. Dunn, frequently in your testimony and in other staff witnesses' testimony, staff points to the importance of affordability in this rate case. Would you agree that affordability is an important consideration?
Affordability is a consideration that staff weighs when making its recommendations to the commission.
Thank you. And specifically on page 56 here on line 17, you state that staff recommends a return on equity of 9.75%. Is that correct?
Yes, I see that.
Okay. And are you aware that the stipulation agreed to a return on equity of 9.5%?
I am aware of that.
Okay. Are you aware that, all things being equal, a lower ROE will result in lower rates than a higher ROE? Is that correct?
All else equal, yes.
Okay. So would you agree that the stipulation, specifically as it relates to return on equity, provides for lower rates than staff's testimony, or I guess your testimony regarding return on equity?
All else equal, a 9.5% ROE would provide a lower outcome than a 9.75% ROE.
Okay, thank you. And on line 14, you recommend a capital structure composed of 54.76 equity and 45.24% debt. Is that correct?
That is correct.
Okay, and that is very close to the stipulation, which provided for a equity share of 54.7%. Is that your recollection?
That is my understanding.
Okay. But again, the stipulation has a slightly lower amount of equity in the capital structure than your recommendation. Is that right?
That's correct.
And again, that will result in slightly lower rates, just considering the capital structure, correct?
Everything else equal, a slightly lower equity structure would result in slightly lower rates. Yes.
Okay. Mr. Dunn, do you participate in other utility rate cases in New Mexico, specifically El Paso Electric or PNM?
I have participated in other cases before this commission that have been in regards to El Paso Electric and PNM, yes.
Have you offered return on equity testimony in those cases?
Objection.
Yes, Ms. Hamer?
Relevance, I don't think it's it's like comparing apples to oranges. There's different there are different utilities, there are different test years, there are different will be one jurisdiction or two jurisdictions. I don't think that's relevant to this case.
Mr. Rushoff?
Yes, I would respond that Mr. Dunn, in his analysis, refers to his return on equity as being sort of consistent with other utilities. Specifically, I'd point you to where I'm sharing here on page 56, lines 19 onto line 1. He talks about his return on equity recommendation is comparable to the returns being earned by other vertically integrated electric utilities throughout the nation. So Mr. Dunn himself recognizes that other utilities are important considerations when making a return on equity recommendation.
But not other.
Ms. Hamer, we have to wait to be recognized just not because I'm trying to be difficult. I'm just trying to keep us organized and mostly also for the sake of our court reporter and our record. Ms. Hamer, go ahead. You would like to respond.
My only clarification is that statement was made with respect to other vertically integrated electric utilities throughout the nation, not with respect to other utilities that he has worked on, and that was what the question was, but you know.
Is that all, Ms. Hamer?
That's all.
Thank you. Okay, I'm going to overrule the objection. I think, firstly, Mr. Dunn is testifying as an expert witness here, and I believe to a large extent his expertise in prior rate cases is relevant. And I also think the particular citation that Mr. Rushoff referred to would permit such a question. Please proceed and ask your question again, Mr. Rushoff.
I don't recall exactly what the question is, but I'll ask, have you submitted ROE testimony in New Mexico Public Regulation Commission's cases for Public Service Company of New Mexico or El Paso Electric?
I have previously submitted testimony for ROE recommendations for Public Service Company of New Mexico.
Okay. Are you aware what the current authorized return on equity is for Public Service Company of New Mexico?
I believe it is 9.45%.
Okay. Are you aware what the currently authorized return on equity is for El Paso Electric?
I believe it currently stands at 9.0%.
Okay. So your recommendation in this case, if adopted, would result in SPS receiving the highest return on equity of any of the IOUs in New Mexico. Is that correct?
Yes.
Okay. And again, that would result in higher rates than the other utilities, all things being equal.
I just want to clarify, I can't recall the exact phrasing of your question, but vertically integrated utilities is what we're looking at here. And I'm sorry, could you state your question again for me, Mr. Rushoff? I just wanted to make that clarification.
Yeah, I just wanted to clarify that all other things being equal, a 9.75 ROE would result in higher rates than a 9.5 ROE in the stipulation.
Specific to SPS only, I think it's difficult to compare different utilities in the context of this case without having the information before me. All else equal, a lower ROE for SPS would result in lower rates.
Okay, that's a fair clarification, and that's the rest of my questions. Thank you very much.
Thank you, Mr. Rushoff. I believe then that concludes the cross-examination that was reserved for Mr. Dunn. I now turn to Staff Counsel, Ms. Amer, to ask if she has any redirect for Mr. Dunn.
Yes, Your Honor, I have one question. You were asked and you answered several times regarding comparison of between your testimony and the STIP, and you said everything else is all things equal. In response, are all things equal in between the case that you evaluated and the STIP?
My understanding is that those things are not necessarily equal. No.
Are the revenue deficiency amounts equal?
The scope of my testimony in this case is limited to cost of capital recommendations, but my understanding is that no, they are not.
Thank you. I have no further
Thank you,
questions.
Ms. Amer. Are those all your questions? Thank you so much. I now turn to hearing examiner Gecko to see if he has any questions for Mr. Dunn.
I do have one question. Good morning, Mr. Dunn.
Good morning, hearing examiner Gecko.
On pages 19 through 21, you discuss credit rating agency reports for SPS. And I'll give you a minute to go there. And I'm gonna
Yes, I'm at page 19.
Okay. Let's go over to page 20. And starting at line 7, you testify that staff reviewed reports from both S&P and Moody's and determined that they view the credit outlook for Southwestern Public Service Company as stable. Did you do an assessment given that those stable ratings of how ROE might place SPS into a different ratings bucket and the amount of changes in ROE that would result in a downgrading of SPS's credit rating?
No, sir, I did not conduct an assessment quantifying the specific impacts of how a change to the ROE would impact the credit rating.
From your knowledge and from this statement of it being stable, can you generally tell me your assessment of the risk that SPS faces of being downgraded, particularly in relation to ROE determinations that might be made by the commission?
I believe that if the commission were to authorize an ROE below what investors' current expectations for a required return for a company of SPS's risk level is, that would be viewed as a credit negative, possibly by credit rating agencies. A higher ROE, all else equal, may be viewed as a credit positive for credit rating agencies.
And so does the word stable tell me anything? Indicate, solidity that, would a so the company requested, I believe, a 10.5. It's stipulated at, and don't hold me to it, but somewhere in that range. That's what I recall. The stipulation, as you just discussed with Mr. Rurashoff, was I believe 9.5. If that were to be reduced to 9.4, for example, would a 1% difference typically move the rating of a utility that is rated as stable? Do you have knowledge to be able to answer that question? And if yes, please answer it.
I could only answer to say that that would be one factor that the credit rating agencies would consider, but I don't necessarily know how or if it would impact their review of the statement that SPS is viewed as stable in its credit outlook.
Okay. And then in your review of the application, is there testimony that you reviewed in this case that puts actual numbers together with testimony that says there is a risk of downgrading? So actual number changes to an ROE or actual number changes to a debt equity that then produce a certain probability of downgrade or upgrade of credit rating that you recall in your review of this case?
I do not recall, Mr. Hearing Examiner.
Okay. That's the extent of my questions, and thank you. I appreciate it. Thank you.
Absolutely.
Thank you, Hearing Examiner Gecko. Ms. Amer, do you have any limited follow-up for Mr. Dunn based on Hearing Examiner Gecko's questions?
No, Your Honor.
Thank you, Ms. Amer. Okay, so I believe then no other parties had reserved time to cross-examine Mr. Dunn. And Mr. Dunn, on behalf of the commission, thank you so much for the time and effort you put into this and your professionalism and participation. You may be excused.
Thank you, Mr. Hearing Examiner.
Thank you, Mr. Dunn. Okay, let's take a break, not a break, a minute here, sort of a break to pause and just discuss what the outlook may be. And I may need to confer offline with Hearing Examiner Gecko, but we have 10 minutes left, more or less 9 minutes until our scheduled lunch break at noon. And I just wanted to talk to the parties briefly about the outlook for the remainder of our witnesses and procedural times. Mr. Rilkoff is the remaining witness, is that correct, Ms. Amer?
That is correct.
And just to confirm with the parties, SPS had reserved 15 minutes to cross-examine Mr. Rilkoff. Is that correct, Ms. Hardy?
That is, but Mr. Examiner, we would waive cross-examination of Mr. Rilkoff subject to the ability to ask follow-up questions.
Okay, excellent. Thank you. That's what I wanted to do right now, is just check and see where the parties were with these times. New Mexico Department of Justice, Mr. Hayden, you had also reserved 10 minutes to cross-exam Mr. Rilkoff. Is that still something you wish to do?
Yes, Your Honor, we would. We'll probably use the whole 10 minutes, but that's probably the limit.
Okay, excellent. Thank you. And large customer group had reserved 30 minutes. Mr. Rushoff, Mr. Arnett, do you still wish to use that?
We'd like to use probably half that. We'll say 15 minutes.
That's helpful. And then FEA LES had reserved 10. That was the remaining party that reserved time. Ms. Miller, are you still planning to use those 10 minutes?
I would say possibly, and it would depend on the questioning
Sure.
that's going to happen before.
Okay, no problem. Just this is only for housekeeping purposes. So that means we have about 35 minutes in cross-examination time scheduled for Mr. Rilkoff. And then obviously hearing examiner Gecko may have some time for questions as well. So the question is that I'll discuss with hearing examiner Gecko in a minute once we get the parties' thoughts on this is, do we have a shorter lunch and then just finish with Mr. Rilkoff after that, after a shorter time, or do we want a full hour for lunch and to come back to 35 minutes to an hour or so of remaining cross-exam and questions before concluding? So just wanted to see what the parties would rather do. If anybody has any strong feelings one way or the other, to have either a shorter lunch or a longer lunch. And I just wanted to check in before making any decisions with hearing examiner Gecko. No, go ahead, Ms. Amer.
I would suggest a very short lunch and try to finish, but that's just my suggestion.
Okay. Is any party completely opposed to that or completely in favor of it? Okay. Well, just like to check, and let me speak to hearing examiner Gecko for a few moments, and then we'll come back on the record. So we're in recess for about 2 minutes here while I discuss with hearing examiner Gecko. Thanks, everybody.
Judy, you're still live on camera.
Okay, everybody, we are back on the record. I just conferred with hearing examiner Gecko, and our preference on on behalf of all the parties' time and effort that they put into this is to have a shorter break for lunch. So we will reconvene at 12:30, and then we will finish with Mr. Rilkoff, and then have any final discussions from hearing examiner Gecko and I regarding post-hearing outlook and considerations. So thank you, everybody. We're in recess until 12:30 and look forward to seeing you back then. Thank you. Okay, good afternoon, everybody. Welcome back to day 4 of our evidentiary hearing. I would like to ask staff to proceed with their next witness.
Miss Amer is going to be handling this witness, so she's going to turn her camera on here shortly.
Hello.
Okay, thank you,
Hello.
Mr. Elliott.
Thank you.
Hi, Miss Amer.
How are you?
Good.
Our next witness would be Mr. Ed Rokoff.
Thank you. Mr. Rokoff, Mr. Lee will swear you in momentarily.
Thank you.
Mr. Rokoff, would you please raise your right hand? Do you solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, nothing but the truth?
I do.
Thank you. Go ahead, please.
Yes, thank you. Could you please state your name
My name is Ed Rilkoff.
and your position at the New Mexico Public Regulation Commission?
I'm a senior policy advisor in the Office of Chief of Staff.
Thank you. As you know, your Staff Exhibit 3, direct testimony, and Staff Exhibit 10, testimony in opposition to stipulation, have already been admitted into evidence. And Mr. Hearing Examiner, before I pass the witness, we were planning on asking Mr. Rokoff the question that was addressed by the other parties that Commissioner O'Connell had, and that Hearing Examiner Gecko was asking the other parties to answer. And so is that appropriate now or later?
Well, thank you, Ms. Amer. The chairman's question was really directed towards the signatories to the stipulation, not the party in opposition. I believe that Hearing Examiner Gecko, with his questions, might get into that. I'll also just remind the parties that subject to further discussion with Hearing Examiner Gecko, it's likely that this question will be in a post-hearing briefing order for all parties to respond to in their pleading. So unless there's any strong opposition, Ms. Amer, I think we might proceed that way.
Thank you, Mr. Hearing Examiner. We will proceed the way you just detailed.
Thank you so much. Okay, so you ready to pass your witness, Ms. Amer?
Yes, please.
That's okay. Thank you. So I believe then that the parties that reserve time to cross-examine Mr. Rilkoff subsequent to our discussion just before our brief recess is New Mexico Department of Justice, first in order for Mr. Rilkoff. Mr. Marcus or Hayden, I turn the witness over to you.
Thank you, Hearing Commissioner. Hello, Mr. Rilkoff. How are you?
Very good. Thank you.
So I have a couple of questions for you. So it ties into another question that was asked earlier, and I don't know if you heard it before, but the question is, will an insufficient rate increase in this case create more frequent future rate cases?
Well, that's a difficult question for staff to answer, since that's the utilities prerogative to when it actually files its rate cases.
So as eloquently stated by Hearing Examiner Gedko and paraphrased by me, if a serial rate case occurs and say rate increases are granted by the PRC, is it possible rate increases might stack on top of each other?
May I interrupt, please?
Certainly.
Mr. Hayden, with your first question, were you referring to a question just that, sorry, I'm dealing with the real-time transcript that I'm speaking so it moves. So you referred to it. The question is, will an insufficient rate increase in this case create more frequent future rate cases? And I've missed some time. Was that a reference to something that I questioned, or was that somebody else?
I believe it came up previously, and I believe you touched on it in the context of another issue, but it resulted in more rate cases.
I made reference earlier to Miss Lee's testimony of that there would be another rate case filed imminently, and then I made generally reference to increases in load and that resources coming onto the system is the context for that, which creates a propensity for a need for frequent rate cases by utilities, because I don't believe, and I could be corrected if I'm wrong, that I made a reference at any point to an insufficient rate increase in this case, creating more frequent future rate cases.
And Commissioner, I didn't mean to imply that.
Okay, just wanted to be clear, and I appreciate it, and I'll let you proceed. Thank you.
Thank you. So I think I had a question out there. Would you like me to repeat it, Mr. Wilkoff?
Yes, please.
So if serial rate cases occur and are granted by the PRC, is it possible rate increases might stack on top of each other?
That's always possible, but every rate case stands on its own merit, so it's not a foregone conclusion that would happen.
So is your answer, it could happen?
It could happen.
Thank you. Let me direct your attention to your testimony. Do you have that?
Yes, I do.
All right. I'm looking at your testimony on page 4, lines 16 through 19, regarding your recommendation in this case. Do you see that?
Could you do a screen share?
Commissioner, would you like me to try to do that?
Sure, yes, if you're able to, that, as I said earlier, can definitely help keep all of us on the same page.
Trying to find
At
where
the same time,
it's
it's 3 lines, Miss Amer. So maybe if Mr. Hayden just reads those 3 lines slowly after having directed us to the precise location in the testimony, we can proceed.
I'd be happy to do that, Commissioner.
Yes, please proceed, Mr. Hayden.
All right, so the paragraph I'm referring to, Mr. Rilkoff, is, for those reasons, from an affordability and customer impact perspective, I recommend that the Commission reject or modify the stipulation as filed and rely on the allocation and rate design recommendations supported by staff witnesses, Dr. Larry Brank.
Yes.
And is that your position today?
Yes.
So are you familiar? Well, no, let me ask another question first. Sorry. Is there a standard limit for a rate increase?
Not to my knowledge.
Are you familiar with expert witness Doug Gigak's testimony in this case?
I am somewhat. I did read it a while ago.
In general, are you aware he supports a higher rate increase than you?
Yes.
So Dr. Gigak found higher rates to be reasonable for this rate case and supported the stipulated agreement proposed by the parties. My question to you is, why should the PRC not adopt the rates supported by the testimony of Dr. Gigak rather than Larry Blank?
Well, I think the question comes down to, how did you determine that the rates are fair, just, and reasonable? And to do that, I relied on the testimony of not just Dr. Larry Blank, but the other staff witnesses as well in determining the revenue deficiency, and also Larry Blank's jurisdictional allocation and his class cost of service and banding recommendations. So that is why, in terms of customer affordability and impact, I think the testimony of Dr. Blank and staff provides more reasonable, absorbable customer impacts than the stipulation does.
So is it fair to say that you disagree? The experts disagree?
That is fair.
No further questions.
Thank you, Mr. Hayden. I now turn to New Mexico Large Customer Group, who had asked for 15 minutes for Mr. Rilkoff.
Yes, good afternoon, Mr. Rilkoff. My name is Austin Rushoff. I'm an attorney for the New Mexico Large Customer Group. It's nice to meet you.
You too. Thank you.
So, Mr. Rilkoff, based on your testimony, is it correct that staff's opposition to the stipulation is primarily based on concerns of affordability? Is that right?
Affordability is one of the key concerns.
And specifically in your testimony in opposition to the stipulation, you discuss your concerns about the rate increases for the residential and small general service classes, correct?
Correct.
And specifically, your testimony states that you prefer staff witness Dr. Blank's proposed revenue allocation compared to the stipulation. Is that right?
I prefer that is one of the facets of the comparison. The other comparisons involve the staff's work in terms of what it determined for the revenue deficiency, and Dr. Blank's testimony on the jurisdictional allocation issue. But in terms of the class cost of service study, Dr. Blank used, I believe, the same cost of service study as SPS did.
Right. And Dr. Blank, the total revenue deficiency that Dr. Blank supported was 48 million. Is that correct?
That's correct.
Okay. And the stipulation permits a revenue deficiency of 90 million. Is that correct?
Yes.
Right. So when comparing Dr. Blank's revenue allocation at 48 million, you would agree that that's not an apples and apples comparison to the stipulation revenue allocation at 90 million rate increase, correct?
Could you elaborate on that, please?
Right. So yes, I can. So staff did not present a revenue allocation it would prefer at a $90 million rate increase. Is that correct?
That's correct.
Okay. Instead, staff's revenue allocation is based on staff's revenue deficiency of 48 million, right?
Right.
Right. Okay. And did you hear my questions of Mr. Blank previously this morning?
Yes, I did.
Okay. And NMLCG witness Justin Bieber testified that the stipulation revenue allocation actually provides more rate mitigation for the smaller customer classes than staff's position. Do you agree with that?
Yes, I did watch that, and I agree with the mathematics of it.
Okay. So Mr. Wilkoff, staff's direct testimony case proposed the 48 million overall rate increase, correct?
Yes.
All right. And you're aware that several of the interveners that joined the stipulation also provided direct cases that provided for a lower overall revenue increase than the stipulation provided. Are you aware of that?
I was not involved in the stipulation discussions, but I can certainly understand that would be reasonable.
Sure. So the parties that joined the stipulation, the interveners that did, do you think they joined so as a give and take of the various positions in the case?
Generally, yes, that's what a stipulation does.
Okay. And staff chose not to join the stipulation and continues to support its original direct case, correct?
Yes.
All right. Are you aware of any previous SPS general rate cases in which the commission entered a final order that completely awarded staff's direct case?
I don't have any history of that.
Okay. What about other New Mexico PRC cases for other utilities? I guess my question is, has staff ever completely won in a rate case and gotten everything that they wanted out of the case?
Not that I'm aware of. I've been at the PRC for about 4.5 years, just for context.
Okay, so there's only been a few rate cases in there.
Yes.
Okay. I want to turn just quickly to the return on equity that staff offered, and I had some questions of Mr. Dunn before the break. Did you hear that questioning?
I didn't catch all of Mr. Dunn's questioning.
Okay, I'll just ask you briefly. So Mr. Dunn and staff recommended a 9.75 return on equity in this case, right?
I believe so, yes.
And the stipulation provides for a lower return on equity of 9.5%. Are you aware of that?
Yes.
Okay, so I used the term all things being equal earlier, but just focusing on the return on equity component, do you agree that the stipulation results in more affordable rates for customers than staff's position when only looking at the ROE component?
That's a very difficult question to answer because there are so many other things that make up the revenue requirement, that changing one assumption in one of those categories, like the rate of return on equity, would be hard to determine that just off the top of my head.
Okay, but the return on equity component, that figure 9.5 is essentially a multiplier that goes into the overall revenue requirement.
Yes.
Right. So if we took the stipulation at 9.5% ROE and inserted a 9.75% ROE as staff recommended, rates would inherently go up. Is that right?
Yes, that would happen, yes.
Okay. Those are all my questions. Thank you for your time.
Thank you.
Thank you, Mr. Rushoff. Now, I ask if FEA LES has any cross-examination for this witness.
Thank you, Mr. Hearing Examiner. We do not have any cross-exam for this witness. Thank you.
Thank you, Ms. Miller. Now, cross-examination having been complete, I ask Ms. Amer if she has any redirect for this witness.
Yes, I do have a few questions, not very many. You were just directed to Mr. Bieber's calculations and said you thought they were mathematically correct. Do they answer a different question than the question that you're interested in?
Yes, those particular numbers, and we're looking at calculations that are derivative calculations of the initial rate suggestions. And, you know, we have numbers that suggest that staff's total residential increases 164.5% of the system average, and the stipulation is 139.5 of the stipulation system averages. And those numbers are useful and they're very interesting, but from a, you know, affordability perspective, and what we want to do is really look at what's happening to the customer's bill. And if you took a look at the customer's system average bill under the staff's rates, they average 6.65%, and the stipulations is 12.12%. And if you look at what really matters to the customer is what is the bill impact? And just for example, on the residential side, the residential service rate that staff proposes is 6.3%, and SPS's stipulation is 13.6%. So you can see that, you know, in absolute terms, and what really matters to customers is that staff's proposal is much lower than the stipulation.
Thank you. I have no other questions.
Thank you, Ms. Hamer. One second. Okay, thank you, Ms. Hamer. Now I ask if Hearing Examiner Gecko has any questions for Mr. Rilkoff.
I do. I have one. Good afternoon, Mr. Rilkoff.
Good afternoon.
My question is partly due to my having to step out of the hearing this morning, and so I want to give you a little context for it because it's based on my review of the testimony that was given by Mr. Zigich, and you may be able to address my question. I don't know. And so the context was the assignment of Cunningham Best to 100% to New Mexico, and you know how that is offset, and that's been discussed throughout this hearing quite often in terms of capacity credit, of course, for that battery. And the testimony said this: if Texas is going to start cherry picking these resources, and we're going to start paying for all of the new cars on a lot full of used vehicles, and we pay for the one new car, that is not an even trade. And it goes on a little bit. You can't let one state cherry pick what they want to pay for and have us pay for the rest of it. They certainly allocate these things at the capital expense level, but there's other resources that are very close in cost and value as the Cunningham Best, and they can certainly trade off one for one on other resources. that made me realize I don't understand perfectly, perhaps, how the capacity credit from the Cunningham BES is proposed to be given according to the stipulation for. I had an understanding that the discussions were about how to accredit that capacity. And let's leave the energy issues to the side for the moment that I discussed with Mr. Trowbridge and Mr. Gable. And so I always saw it as, taking from a total pie. And what I see here is an identification by Mr. Zigich of, possibly when that trade-off is made, that particular resources can be identified. Could you explain how and they can certainly trade off one for one on other resources. Is that in your expert area of knowledge? And I'm asking because of the procedural point that we're at right now.
Yes, Mr. Hearing Examiner. Unfortunately, I was hoping I'd be able to answer the question, but it is beyond my technical expertise. And
okay, then I may discuss with Mr. Schaefer offline what, and consult with him with respect to my question, since he has the context of having been in the discussion, and sometimes there's nuance to that. So I did not have, based on the discussion that you've already had, my other questions have already been answered that I would have had for you. So thank you.
Thank you.
Thank you, Mr. Wilkoff. And Ms. Amer, do you have any limited follow-up for Mr. Wilkoff based on Hearing Examiner Gecko's questions?
No, Mr. Hearing Examiner.
Okay, well, it seems like we have reached the end of our cross-examination and our witnesses. I believe that Hearing Examiner Gecko and I will want to have a brief discussion offline, but we'll be back in probably 5 minutes. Let's take a recess until 1:05 p.m. and we'll resume the proceeding and make any last final preparations. So we're in recess for 5 minutes until 1:05 p.m. Thank you, everybody. Hey, everybody, good afternoon. It's 1:06. We're back on the record. Hearing examiner Gecko would like to share something with us here in a few seconds, but before that, I just wanted to follow up as we're getting to the very end of our evidentiary hearing and the ability to enter evidence into the record and check with SPS to make sure that all bench requests have been uploaded or submitted for review to the parties or filed. I believe there might be one pending, Ms. Hardy.
Mr. Examiner, I believe that we have two pending, request numbers 3 and 4, and we will have those in today. The request for information regarding the PTC transactions, as we mentioned, the exhibit would need to be confidential. So we're preparing to file a request for confidential treatment and supporting affidavit in accordance with the terms of the protective order with respect to that exhibit. So we're working
Okay,
on that.
so how do you because I think we're pretty close to the end of our hearing. Do you have any thoughts about how you might want to handle that, or how you think the hearing examiner should handle that?
In the past, in this situation, I believe the hearing examiners have indicated that they will include the bench responses in the record, even if they're received after the hearing, as long as no party objects. And the parties would have an opportunity to review the responses when they're provided.
Okay. Do any party have any thoughts on that? What Ms. Hardy just mentioned, that possible solution? Is there any opposition or any strong feelings against what Ms. Hardy has described? Okay, well, in that case, we can admit those into the record, subject to review and objection by any of the parties in this case. So they'll be filed into the record, right, Ms. Hardy, into the docket?
Correct.
Okay, and so just for Mr. Lee's purposes as well, okay, Ms. Amer, go ahead. You have a thought?
Just a thought, if a party did object or wanted to cross-examine at that point, would we be able to?
Well, I don't know if we'd have the opportunity to cross-examine. I think, and correct me if I'm wrong, Ms. Hardy, I think Ms. Hardy was stating that there would be a conditional admittance into the record unless a party objected. So that if a party objected, it would not make it into the record.
Correct.
Thank you.
Is that acceptable to staff, Ms. Amer, or do you still have reservations?
Well, then then it would be like, it's hard, it's hanging out there. It's not part of the record, but it's on appeal, it would be part of the record proper, right?
You mean if the final order in this case were appealed,
Right.
the pending,
Right.
go ahead.
When you say it's not part of the record, it actually would be part of the record proper on appeal.
Unless a party objected to it. I think that's what Ms. Hardy is suggesting.
And it would just be withdrawn then?
Yes, I think it can be admitted conditionally.
I would imagine that if a party objects, depending on SPS's position, there may need to be an opportunity to respond to the objection. But in the past, there haven't been objections. Although there certainly could be, but.
Hearing examiner Gecko, do you have any thoughts?
I do. My, my concern's more focused, and only this being, I'm very early in this position, is more with the cross-examination. Like, I don't see, and Miss Hardy, you just reflected this, of there's never been an objection to the admittance of the item. And when the discussion started to turn towards whether it would be in the record or not, I want, I issued the bench requests that I issued because I want them in the record. And so for me, the real nugget of the discussion is with respect to due process and possibility of examination or response. Due process in these regulatory matters take different forms sometimes, but that's where my focus is in my head right now. And so it would be a matter of, that the easiest route is if objections were waived and cross-examination were waived, and there was an understanding that there could be briefing upon it. But that's not me forcing that on the parties. I'm just looking at this pragmatically and trying to understand which way to go.
Let's take a 5-minute recess, and I'll discuss this further with hearing examiner Getco so we can come to an appropriate solution. Good afternoon, everybody. We're back on the record. It's 1:38. Thank you for your patience. Hearing examiner Getko and I have just been discussing some matters, and I'll let him share his thoughts with respect to the bench request. Now, just before handing him or giving him the floor, Ms. Hardy, there were two bench requests pending, you said. One was with respect to Ms. Koch's testimony, and then just remind us what the other one was for.
Sure. The other one is on the ancillary service value of the Cunningham battery energy storage system. So they're both
okay, and
straightforward questions, and I was going to say they're both very straightforward questions and very straightforward answers.
Thanks. And are both will SPS be seeking confidential treatment for both?
No, only of the exhibit to Ms. Koch's response, which shows the value of the PTC transactions.
Okay, excellent. Okay, thank you. Hearing examiner again.
Sorry, it sounded like a strange cutoff. Can everybody hear me?
Yes.
So, Ms. Hardy, we discussed a few things, and one of the things we discussed is the confidentiality, because of it, it introduces other elements. And if, I don't know if you're able to speak to this, but if the confidentiality treatment is only with respect to the transfer costs or the value that is paid for the for the PTC on the market, I don't, my assessment at this point is I don't think it's at the core, and it's more of the timing issue. The rate, we've already publicly testified to the carrying costs on the DTAs and the temporal matters, and we've spoken in hypothetical dollars. And so my question with that context is, if you eliminated the exact cost of, the transfer cost on each transaction and the value paid for the DTA or for the PTC, is it still confidential?
So the question, as we have it, asks us to provide our generated tax credit value by resource, associated transfer cost related to those tax credits, transfer cash received, and the related carry forwards remaining. So those details are confidential because they would allow the market to assess the credits that SPS has sold, how many it has remaining, what it impacts the market. So we are providing a public response that is a narrative, but the exhibit that's confidential is a spreadsheet that provides all of those details. It's very detailed information that would impact the market.
Right. And yeah, even providing how long they're on your books for and such provides insight into what's going on.
Right.
The other thing we talked about is, I would likely need to reconvene after it's filed, and it'd be filed with an affidavit, but to allow the parties the opportunity to indicate whether they have a need to ask questions with respect to that exhibit, and then go into confidential session if they do with respect to the details within it. And so the question would be on the table of whether Ms. Koch is available if I were to do that tomorrow morning at 9 a.m. for something I would imagine to take between 15 and 30 minutes or something like that if it went smoothly, and assumptions aren't always correct. So is there availability of Ms. Koch?
I would need to find that out, Mr. Examiner. I don't know the answer to that question right now.
And then, can you remind me when you thought you would be finished with numbers 3 and 4?
I think that they will be in this afternoon.
Do you have an idea of what time that might occur by?
So the one on the Cunningham best ancillary services value is ready to go, I think, as we speak. So that one should be in shortly. And then the other response, I believe, should be in this afternoon as well. And I think before 5 p.m., I'm hoping maybe within the next hour we could get it in.
And I'm thinking off the cuff here a little bit and learning this position too. If you have a public version and an explanation of it, is it worth my review of that and then making a determination of whether it's even necessary to file the additional information, like perhaps, being that the bench request came from me, it presents an opportunity here almost immediately to simplify this issue to some degree based on my reading of that piece. And
I think that, well, I think the details that you had requested really are in the exhibit. I mean, I'm happy to send the narrative response. It's not ready to go yet, the narrative response, but I think it doesn't include the details.
right.
Yeah.
Okay. Not even the ones that I've kind of expressed here in this small conversation as being, at the core of the matter, which is time.
Right.
Right. At the risk of overcomplicating, then I do apologize if it's a decision that early in my career in this position is not a good one, or that I'll learn with time was not the right way to handle an issue. And I would like to proceed with it and receive it and go through the proper due process and with apologies say that I think we need to reconvene then simply for the purposes of addressing whether any party has cross-examination with respect to that filed bench request.
Mr. Examiner,
Yeah,
apologies.
no, please go ahead.
Okay, I didn't mean to interrupt you.
No, you didn't.
I was just going to say that it's not unusual for us to receive bench requests on the last day of a hearing, or to provide responses after the hearing concludes. I think it's a pretty common occurrence. And in the past, it hasn't been an issue. I mean, we haven't had to reconvene the hearing. I understand if you review it and have questions about it, that you could certainly do that. But parties don't normally cross-examine witnesses on bench responses because they're information that's requested by the hearing examiners or the commission and is being provided. So I don't actually really think that even an objection would be appropriate because it's information that you've asked for.
That's helpful. It supports certain understandings I've had and have also been part of some discussions recently, in my world in OGC for so long, and the consistency of due process. And I guess I'd want to open the floor right there and in particular see if there's any additional support for that it may be just that easy. Mr. Rushoff.
I was going to suggest a potential path forward is from the NMLCG's perspective, we have no problem with SPS submitting that bench request later. And I believe if a party did have some sort of objection to that response, there'd be an opportunity to file a motion to strike or something of that nature to address that if there were concerns that came up. So I think that might be an easy way to let the information come in, and then once folks review it, proceed if they feel like there's a reason why it shouldn't be in the record.
Thank you, Mr. Reichef. Yes, excellent. Mr. Elliott.
Staff wouldn't object to that.
I have a co-hearing examiner, co-hearing examiner Schaefer, if you'd rather talk, and we wouldn't make it be as long this time off screen, but I open the floor for you to give your input as a group here first.
Sure. I think that the commission's greatest concern is just to make sure that parties have an opportunity to view any evidence that's been admitted or potentially admitted into the record. So as I was saying a few moments ago before we recessed to discuss this issue, if the parties are not opposed to admitting this into the record subject to their review, a bit similar to what Mr. Rushoff had just articulated, then I'm happy to proceed in that fashion. But the principle that I just want to enforce here is that any piece of evidence that is admitted into the record, that the parties have a fair opportunity to review that or object to it. And as I said again, the solution that I was articulating a bit broadly before the recess, and what Mr. Rushoff had just articulated a bit more concretely, is something that I find to be feasible and practicable.
Then, by my understanding of everything that's been spoken just now, I think we've arrived at a solution that everybody is amenable to, and that provides a path towards due process, that guarantees due process, and let's proceed along that front. I think I appreciate the discussion. As many questions as I ask and curiosities and such, like some of it is learning, and maybe hearings will get a little bit more efficient with me moving forward. And I want to just say thank you for working through this and the various questions I've had for the last few days. So thank you.
I'm on mute after. Okay, so it looks like that matter with respect to the bench request has been resolved. And I think the only other issue that hearing examiner Getko and I wanted to discuss was perhaps a post-hearing briefing order. Is that correct, hearing examiner Getko? Mr. Rushoff?
Yeah, I apologize as we're trying to wrap up here. There was the open matter of the corrected NMLCG Exhibit 4, Mr. Bieber's
Yes.
Testimony. We have submitted that to the Dropbox. So
Okay.
if that's been seen and available, I'd like to move to admit that at this time.
Sure, just let me, of course, I clicked on the close button on the Dropbox. Mr. Rushoff, normally I receive notices in the email, and I didn't remember seeing one, so
I just looked for
I
it,
do
Judge,
see
and
it
I
here.
didn't see it.
Yes, I see it. You see it too, Mr. Lee?
I haven't seen it, but I will look again.
There was
Okay, Mr. Rushoff, I see confirmation of that upload to the Dropbox at 12:27 p.m.
Yep.
And that is exhibit, Mr. Lee, that's exhibit 4, NMLGC, exhibit 4, testimony in support of stipulation, Bieber, corrected 1.
Thank you, Judge.
Thank you. Okay, thank you, Mr. Rushoff. Are there any other thoughts before we move to the conclusion of our hearing and a discussion on the post-hearing briefing order?
I only want to clarify one other matter that when we went offline, I used a bit of that time to make a determination that I I can use the record and internal advisory staff to help me understand any further questions I have with respect to Mr. Zigich's testimony while I was at the open meeting. So that issue has been resolved as well. That question that I had asked to Mr. Rokoff and we had discussed. So for the clarity of that, I don't think that was on anybody's mind, but it was on mine. So thank you. And nothing else from me.
Thank you, Hearing Examiner Gecko. I think now we'll enter into just a brief discussion on post-hearing briefing. Suffice it to say that Hearing Examiner Gecko and I will be filing an order shortly with respect to the topics that we feel deserve subsequent treatment to the evidentiary hearing. We don't have those obviously right now, but just wanted to alert the parties that there will be post-hearing briefing here. And with that, I will just ask if the parties have any other thoughts or concerns to raise before we close the hearing.
Mr. Examiner,
Yes, Ms. Hardy.
with respect to the deadline for post-hearing briefs, I just wanted to mention that SPS is fine with the deadlines that are established in the rule, which I believe is 20 days after the final transcript is posted.
Okay, thank you, Ms. Hardy. Okay, well, just once again, please accept my expression of gratitude and appreciation for everybody that put all the time and effort into this proceeding and their pre-filed testimony, in their verbal testimony here at the hearing. It's very much appreciated, and I value working together and improving our hearings every time we meet. So thank you so much. And this hearing is closed. Thank you, everybody. We're in recess.
Thank
Thank you,
I
Mr.
just want
Lee.
to say thank you to Mr. Lee.
Yes.
Thank you,
Mr. Lee.
For your